December 4th, 2025 State Ethics Commission meeting to order. It's great to be here in Carrollton, Georgia this morning. The way everything's set up, it was great. Great hospitality for the folks over here in Carrollton. I've got an agenda here for everyone this morning. It looks like it's in 13 parts. I understand that we do have a few changes to the agenda as presented. Under item number 3, which are preliminary hearings, it's my understanding that item B, which is case 24-0044-C in the matter of Renee Godwin, that's going to be switched to the consent order calendar. Is that correct?
Yes, sir.
All right, that's going to now be item 4L on the agenda. And again, I believe it is my understanding that under item 4, consent orders, case B, which is 24-0124-C in the matter of Chelsea Thompson, that's going to be removed from the calendar at this time. Is that correct?
Yes, sir.
That will be scheduled again for whatever date we establish for the next meeting. Is that right?
Yes.
And the intent is that for that to be included on the preliminary hearing.
Yes.
All right, has everyone else had an opportunity to review the agenda as set forth? I'll go ahead and make a motion to approve the agenda as amended. Do I have a second?
Second.
We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, we've got the agenda then as changed. We're going to go ahead and move. Well, let me ask this first of all before we set this up, just so I know what kind of length of time that we're looking for here. Who's present here for the preliminary hearings other than commission staff?
I'm here, Catherine Bernard, on item 3 for GRA Incorporated.
Okay. Are you going to be the only one that's doing any speaking or whatnot with regard to that case?
I believe so.
Okay. Thank you very much. Is anyone else here for any preliminary hearing this morning? All right. Is anyone present for any of the consent orders that are listed this morning?
Good morning, Brian Tyson, here for Business Supporting Schools and the Children First consent matters.
So those are items 4, C, and D that are on the agenda. Thank you very much, Mr. Tyson. We'll get to you as soon as we can. We have a pretty full agenda this morning, so we'll try to get you out of here when we can. I'll go ahead and move to item number 2 on the agenda, which is... Oh, I'm sorry.
Apologies.
That's okay.
We have two of us also here on those same matters, C and D. Sarah Beth Myers and Seth Levy for New Southern Majority.
What was the second name, Seth?
Seth Levy.
Levy, okay. All right, anyone else that's here on any consent orders for this morning? All right, we're going to now go ahead and move to item number 2 on the agenda, which is review and approval of the meeting minutes for the September 17, 2025 regular commission meeting. Have all the commissioners had an opportunity to review those minutes?
Yes.
Does anyone have any changes with regard to those minutes? I just want to make sure that I didn't mark anything on those. I do not see anything marked. All right, I'll go ahead and move to approve the minutes that's presented to us from the September 7, 2025 commission meeting. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right, we'll approve those minutes as presented to us. We're going to go ahead now and move to item 3 on the agenda. These are the preliminary hearings. The first case that I will call is going to be item 3A on the agenda. It's case 24-0098C in the matter of Nicole, is it Messiah?
Yes, sir.
All right. Is anyone here to speak on this preliminary hearing other than commission staff? Again, hearing none, go ahead, Mr. Knitter.
Thank you. Good morning. This is in the matter of Nicole Messiah's case 24-0098C. A little bit of background on this case. Ms. Messiah was a candidate for the DeKalb County Commissioner, District 3, which was a special election held on November 5th, 2025. 2024. She advanced from that to a runoff, which was held on December 3rd, 2024, and she was successful on her seat. And then she filed her DOI in a timely manner. She qualified between April 1st and April 5th of 2024. Procedurally, this case came to us as a third-party complaint, originally filed on September 9th of 2024. There was an amended complaint and then a second amended complaint filed on February 17th, 2025. Ms. Messiah confirmed she received the original complaint. And in fact, I know some of our current commission members were not present at our June meeting, but Ms. Messiah did come to that June meeting. We had gone through part of or most of the presentation, and at that point, we took it off so that she could provide the state the financial records which we had subpoenaed previously, and with the intent that we would take a look at that and hopefully resolve. If not, we would come back in the December meeting for a hearing. And so that's what brings us here today. Since that meeting, when Ms. Messiah was present at the commission meeting, she provided myself with the financial records. And looks like
Ms. Messiah?
Yes.
I'm
Okay.
fine, express my apologies for the delay.
We're into your case.
Okay.
At the moment, Mr. Knittel just began his portion of the case. Or do you plan to speak with regard to the preliminary hearing this morning?
I do. Yes, sir.
All right, we're going to allow Mr. Knittel to go ahead and proceed, and then we'll give you an opportunity to speak as well.
Okay, next, thank you.
All right, so in any event, the first violation was failure to file a personal financial disclosure statement within the required period of time after qualification. 21-5-50 requires that it shall be filed with the commission no later than the 15th day following the date of qualifying as a candidate. In this particular case, as I stated before, Ms. Messiah qualified on or about April 5th, 2024. That was the week, when qualification occurred. And then, if you look here, this is from the Easy Campaign finance portal from the county, where she had filed her personal financial disclosure statement on October 11th, 2024, which is substantially after the required time period, and more importantly, it was after the third-party complaint came in, which is what precipitated this matter. That complaint was filed on September 6th. And so she failed to file her PFDS within the applicable time period. She has obviously since filed that, but that's one violation. In a special election, there's different filing requirements, as this commission knows. There is a 15-day prior to a special election, there has to be a campaign contribution disclosure report filed. And in the case of a runoff, there's 6 days, there's another CCDR that needs to be filed 6 days prior to the special election runoff, which is what we're talking about in this case. Our rule 189-3-.01 also informs candidates that if they're in a special election, they must also file a December 31st campaign contribution disclosure report. As I stated, Ms. Messiah filed her DOI on May 19th, 2023, and then a committee on May 23rd, 2023. The CCRs that were filed by Ms. Messiah, this one here was filed on November 1st, 2024. That had been her most recent CCDR filed at the time when this complaint took place. She has since filed the missing CCDRs. I want to make the board aware of that. But at the time when this complaint was out there, they had not been timely filed. And then she did have, she raised approximately $88,000, and she had a net balance on hand of approximately $35,000. Mr. Yap, are you able to clear it up? It's a little hard to see those numbers. Is that as clear as it can get?
No, that's it.
Okay. I stated, she advanced from the special general to the special election runoff. And then violations related to campaign contribution disclosure reports. She had failed to file the CCDR for the runoff 6 days prior to the special election. And she also failed to file the December 31st, 2024 CCDR in violation, both of those in violation of 21.534 C and C4 and C2 respectively. As I stated, Ms. Masai has since filed the missing CCDRs. The runoff report was filed on June 20th of this year, and her December 31st report was also filed on June 21st of this year. And so ultimately, her campaign had approximately $137,000 in contributions and had made approximately $115,000 in expenditures. There's reasonable grounds to believe that Ms. Masai violated our act in these 3 ways by failing to file her personal financial disclosure statement within 15 days of qualifying for election, failing to file her campaign contribution disclosure report in the special election runoff 6 days prior to that election, and also she failed to file her December 31st, 2024 CCDR in violation of 21.534 C2.
These are the, excuse me, these are the same alleged violations that are on the case summary report that were prepared, but they're just not in the same order, is that right?
That is correct.
I also noted that the case summary report that was prepared for the commission, it's referred to as in the matter of Nicole Messiah and the committee to elect Nicole Messiah. Are these going to be, are these alleged violations by Ms. Messiah individually, or her and the committee? I need to make sure that I'm clear on
I
that.
apologize, her and the committee.
And that would be for all 3 of the violations?
Yes, sir.
Did you want to say something? You did. Commissioner Thompson?
The December 31st report that was filed, was it a termination?
No, it was not. She won her seat, and so she's in office currently.
Okay.
It's not a termination.
Okay. Did she file her June 30th report?
Yes.
Okay.
All right, so there's no issue, as far as I would understand it here then, that she did not file her CCDR 6 days prior to the special election, is that right?
Yes, that's correct. She did not file it.
I mean, from y'all's standpoint, it's definitely not there.
Correct.
All right. She didn't file the December 31st, 2024 election year CCDR, correct?
That is correct.
And she did not file her PFDS within 15 days after qualifying, correct?
That is correct.
Anything further, Mr. Canetto, on behalf of the commission?
No, sir.
Staff? Okay.
I do have one question.
Yes.
Did you turn your mic on?
Val?
Yep.
I think I heard you say the 2 CCDRs have been filed.
She has since
But
filed them. Yes, they are filed
Has
now.
the personal financial disclosure statement been filed?
Yes, that has also now been
So
filed.
these are all filed, they're late.
Yes, correct. And just what I understood the question being at the time of this complaint, so yes, they're filed now, but they were
No,
not.
this is, I want to make sure my hearing was correct. So I heard you say the CCDRs have been filed. I didn't hear you say,
Yes, all 3 of the missing reports have been filed.
okay, thank you.
And I'm sorry if that created confusion, but you did understand the question as I phrased it, so I apologize.
Any other questions?
Ms. Messiah?
Thank you so much. As Mr. Knittel has shared, it was a third-party allegation by someone that was running an election with me, Mr. Tommy Travis, presently here recording as well. He filed against myself and another candidate, the two female candidates that were in the race once it was realized that there was going to be a female candidate for presidency in order to gain an advantage. At the time that I had actually filed, at the time of the election, I actually initially filed more of the CCDRs than I needed to. Mr. Knittel actually shared that information the last time we were before you related to this particular matter. So I had been filing more than what had been expected and what had been required of me. When Mr. Tommy Travis filed the complaint, there were 6 allegations initially, and then Mr. Knittel filed a subpoena, then realizing that we were in a special election, and customarily the commission races take place during the general primary. However, due to a decision by the VRA in DeKalb County, this particular election was to take place during the general election opposed to the general primary. So there had been some original confusion as to what specifically needed to be filed by Mr. Knittel when the first allegations came out. It had been determined that the allegations that Mr. Tommy Travis had made were in fact incorrect because we had a special election, so it wasn't on the same time schedule that had initially been anticipated. When I was handling the CCDRs and the disclosures myself, again, those were filed ahead, then brought in a campaign manager and team, and there was a late filing in terms of the 6 days before the runoff. That is something that Mr. Knittel had brought to my attention, and once brought to my attention, it had been filed along with, and I'm not, and this is part of the challenge in terms of the consent, because again, the last time we were before you, there were additional CCDRs that had been filed that was in and around the time that those others had been due. So it had been shared, and again, you know, just watching video, it had been shared that that would suffice for the CCDRs that were required, thus not making them late. Since the last time we were before you, that has apparently changed, and when I did read the consent, it was now that there were 3 late opposed to 1 being late, 1 that 6 days before the runoff was actually the runoff election. As shared, I even filed the, I think it was the June, ahead of what was due, and since I've been handling it myself, went back to filing them early. So it wasn't for a disregard. Apparently there had been some confusion even with Mr. Knittel as to when, what, and how. I have been constantly filing more than what I was supposed to. And even before, last time we were before this commission, there had been a discussion in terms of my, my bank statements. I provided those to Mr. Knittel during the last meeting, even though I didn't have to. Last time we were before this board, it had been realized that when Mr. Knittel had sent this, you know, subpoena, that he actually had utilized the wrong address, and so I had not received it. Notwithstanding, I still, the last time I was here, brought my statements and just provided them to Mr. Knittel because there's nothing to hide. Everything has been filed, everything is up to date, and there are no issues as it relates to that. So at this point, the 6 days, I completely understand. The other 2, I'm really uncertain about, and even with the initial consent provided, it would have been for 1 day, and then that has now changed. I'm really confused about that. By way of example, when it comes to the 15 days, it was due on 10/21, and that had been done on 11/1, and as far as the runoff, I think it was due on the 5th and that had been done on the 3rd. So again, there had been discussions about how close in proximity they had actually been filed, and sufficing, somebody filed earlier, some filed, a day or two later, and Mr. Knittel saying that those would suffice and not be considered late, the only one being that 6-day runoff, which, when it had been provided to me, was only gonna be a fine as suggested of, I believe it was $100. And again, when I recently got the consent, now there's 3, and it's 3 times that amount. So opposed to just paying them out, and it was advised that I could even use my campaign funds. I shared with Mr. Knittel, there's no way in the world that I'm doing that. And even as I stand before you, have my own personal check from my own personal funds, because when individuals have contributed to my campaign, it has been for the benefit of the campaign so that I can advance forward and do what I need to do to be elected. Not to pay any fines based on it being late, whether it be based on my my campaign manager filing late or anything else. So whatever this commission decides, I am ready to pay and prepared to pay directly out of my own personal, but my anticipation, based on the conversations that have been had with Mr. Knittel, it is based on one late filing, one CCDR being filed late, and that was the 6-day requirement before the special election had taken place.
All right, so if I'm hearing you correctly, with regard to the 3 allegations that Mr. Knittel has talked about this morning, you acknowledge that you didn't file the CCDR 6 days prior to the special election runoff. That's number 1. And I want to make sure I'm understanding this correctly. With respect to the other 2 allegations, you're saying that those were never included in any type of complaint that was served upon you, and this is the first time that you're actually hearing about those?
No, sir, that's not what I'm saying. I'm saying that when we had a discussion about it, Mr. Knittel had shared that they were in close, either they were done right before they were due or soon after, and that those would not be considered late just based on a proximity of time. That is something that he attested to. It's the last time he was before us, it was on video. That's something that he had shared, and so when a consent had been sent over to me, it was for the one CCDR, and that was the 6 days. And even, again, in conversation with him afterwards, when we were advised by this body to have a conversation, because it was just like, he admitted that I had filed several ahead of time and filed more than what I was required to and didn't have to file, that we have a conversation, and it was based on just one, that 6-day, and it would be a fine, and I think he said about 120, something like that. But when I got the consent, it said something in Converse.
Commissioner Thompson, did you have something?
So you may have just clarified what I was going to ask. You referenced the first consent order.
Yes, sir.
Do you have a copy of that first consent order that says there was, that the staff was offering you one violation?
I can take a look at it. I'm sure that I have something there, because the other thing that was in that consent was that I filed more CCDRs than what I had to. And what was important about including that language was, at the time, the candidate, a former candidate that was in my race, actually was sending out text messages and emails saying that I was being investigated by the Ethics Board and the Attorney General.
So let me say this, just to interrupt. It has never been the position of this commission or the staff where we say, well, you got close enough to the due date, because we try to take all that out of it so that we treat everybody fairly. So I would be surprised to see that, and would like to see that in this consent order. It also, I was at that meeting, and I don't remember it being said one violation. That's all I had.
Again, the other thing that I would say is that, regardless of what may be presented in a consent order, the violations are violations, and the violations will speak for themselves. Mr. Knittel, I would like to hear from you with respect to the two allegations which relate to the December 31st, 2024 CCDR, and then the PFDS alleged, violation based on what Ms. Messiah's mentioned this morning.
Thank you. Let me see if I can clarify some of this. When the third-party complaint came in, there were several allegations. One of them also being missing the personal financial disclosure statement. After investigating,
When was qualifying?
I believe it was April 1st through, if I can just kind of go back to I have the dates here, April 1st through April 5th of 2024.
I think that was the slide, I think.
Right here,
Yeah.
yes.
What does that say? I can't.
Qualifying period ended on Friday, April 5th, so it was I think it was April 1st through April 5th.
When was the financial disclosure filed for the first time?
It was filed on October 11th, 2024.
So it wasn't just a couple of days.
Correct. It was substantially after the due date. But I think I can clarify some of what Ms. Messiah said. I would like to do that.
Sure.
Because I think I would disagree with the synopsis. Once this case was being investigated, we realized this was a special election. The only remaining violation at the time was the personal financial disclosure statement. What Ms. Messiah is referring to as filing extra CCDRs is because I indicated to her, once I realized it was a special election, because I also did not realize it was a special election initially. She had been filing according to the schedule, the January 31st to April 30th. That's when I indicated, well, you've actually filed ones you don't need to file. In essence, you filed extra CCDRs. That does not mean you don't have to file the 15 days prior, that you don't have to file the runoff one if you are in a runoff, which she was, and I advised her in an email that the runoff would be due 6 days prior, and also there would be December 31st report required. So that's the clarification on that. So initially when we talked about a consent, which did not occur, it would have only been for one late PFDS. So I think that may be some of the misunderstanding.
So it wasn't just limited then to the not filing the CCDR 6 days prior. You were talking about at that time the PFDS.
Back when I first spoke with her, okay? But, so the consent didn't happen in December of 2024. The consent wasn't completed. So, before I did a consent, I went and looked, and those reports that I indicated to her in an email would be required to be filed had not been filed. So I amended the complaint, which is what was presented to the commission today, related to the 6 days prior to the election and the December 31st report. That's all I have to say about that.
Okay. Ms. Messiah, I will give you another opportunity to get you to address anything that Mr. Knittel just said, and then we're going to be ready for a motion.
Sure, and it was and at that point, it was the 6th day. I completely agree in that Mr. Knittel had sent the email, because we have been emailing back and forth, and again, in that initial consent, there was specific verbiage that I had filed more than what I had supposed to, and in the email he did send to say that you have to file the CCDR 6 days beforehand. So at that point, that is what was due. Everything else had been filed. It was that 6th day that was what was coming up that had to be done. And again, the consent changed from even the last time, and I get, it's consent, and that's something entirely different. But when we spoke, and it was before this body, it was because I filed the additional ones, and more than what I was supposed to. One of those were in, at least in close proximity, I believe it was the one where it was 15 days, let's see, before the special election.
But that's the one that Mr. Knittel just identified as, April to October, right?
It's not an alleged violation either. Excuse me, not an alleged violation. It's not part of the violations.
Right, but where it had been filed, and it did not have to be filed, I was advised that that would have satisfied one of the CCDRs that was required to be filed, thus it not being late. Because it wasn't a requirement for me to file, and I filed, actually filed more than what I was supposed to.
Okay. Any questions for Ms. Messiah? All right, I'm gonna go ahead and make a motion that reasonable grounds exist to believe that the respondents violated the Campaign Finance Act when they failed to file CCDR 6 days prior to special election runoff in violation of OCGA 21-5-34C4. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? I'll make a motion that reasonable grounds exist to believe that the respondents violated the Campaign Finance Act when they failed to file December 31st, 2024 election year CCDR in violation of OCGA 21-5-34 and Georgia Comp Rule and Regulation Rule 189-3.018. Do I have a second?
Second.
Got a motion and a second. Any discussion? All in favor say aye. Aye. Any opposed? I'll make a motion to find that reasonable grounds exist to believe that the respondents violated the Campaign Finance Act when they failed to file a PFDS within 15 days after qualifying in violation of OCGA 21-5-50. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. Anything else with respect to this case, Mr. Knittel?
No, sir.
Ms. Messiah, Mr. Knittel, and anyone else on the commission staff will be available to discuss this further, should you wish. There's 30 days before it'll be referred to the Office of State Administrative Hearings. Is that right, Mr. Knittel?
That is correct.
Okay. You can contact Mr. Knittel and see if anything can be resolved with respect to the case.
Okay, thank you so much. I appreciate the submission.
Thank you for coming. I'm going to call the remaining preliminary hearing. It's 3C on the agenda. It's case number 25-0060-C in the matter of Georgia Republican Assembly Incorporated, Georgia Republican Assembly PAC LLC. Mr. Baywalt, looks like this is your case, and then Ms. Bernard, you're here to speak as well.
Yes, although it is by special appearance, since we do deny jurisdiction as to Georgia Republican Assembly, Inc., I have no position as to GRA PAC.
Is anyone here to speak with regard to Georgia Republican Assembly PAC?
No, sir, and that was discussed prior to this. Counsel for GRA PAC LLC, Mr. Sabatini, he agreed to waive the preliminary hearing. He's stipulating to reasonable grounds. There was a notice of violations that I filed 15 days ago on both parties, and categorically, there are 3 statutes that are violated a total of 15 times. And on the notice of violations, I did break up each categorical series of violations on that notice of violations. Mr. Sabatini did see that. We are in agreement for reasonable grounds pertaining to his client. I have an order that was presented with the e-binder for Mr. Chairman's signature.
Right, I've got that in the packet that we were provided as handouts. It's in the matter of Georgia Republican Assembly PAC. It's an order waiving preliminary hearing and stipulating to reasonable grounds. A question that I had about this, again, just for clarification purposes, are these the same alleged violations that apply to Georgia Republican Assembly, Inc.? Does anyone have any questions for Mr. Baywall with regard to the order waiving preliminary hearing and stipulating to reasonable grounds? Hearing none, I'll make a motion to approve the order waiving preliminary hearing and stipulating to reasonable grounds in case number 25-0060-C as applies to Georgia Republican Assembly PAC LLC. Do I have a second?
Second?
We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Okay, Mr. Baywell, that order waiving the preliminary hearing and stipulating to reasonable grounds has been approved. It looks like it has not been signed by you to this point. I don't need it right this second, but we'll get you, go ahead and get your signature on that, and then I will adopt that pursuant to the motion from the commission.
Yes, sir.
All right. So it sounds like then we're going to proceed with this case as it applies to Georgia Republican Assembly, Inc. Ms. Bernard, again, I want to narrow this down as best I can. Is the argument today going to relate exclusively to jurisdiction, or is it going to be jurisdiction and then the substantive allegations that are set forth, in the complaint?
Well, Mr. Chairman, as a preliminary matter, we have never received the required verified complaint attaching the GRA, the Georgia Republican Assembly Incorporated, to the complaint that was made and apparently substantiated and reasonable grounds stipulated to against GRA PAC. They are two completely separate and not connected entities, and so we do have material that we are available to present to the commission today on that subject. But as a preliminary matter, we do deny jurisdiction, enter only a special appearance today, and we have not received the requirement under 2156, Section 10A, that requires that in order to conduct a preliminary investigation of the merits of a written complaint, the staff attorney must verify under oath that to the best information. And this was provided in the initial complaint against the GRA PAC, which again, it appears that there were stipulated grounds that that organization has committed campaign finance violations that would be under the jurisdiction of the commission. However, such written verification was not made against the Georgia Republican Assembly, which is not an organization that engages in any campaign contributions or any other activities that would place it under the jurisdiction of the State Ethics Commission where we are here today. So we're prepared to offer whatever information would be helpful at this stage. Certainly the fact that the allegations against GRA PAC have been stipulated to by their counsel. This is the first we're hearing of it, and so we'll certainly take that under consideration. But at the outset, since we have not received any such verification from a staff attorney under oath, we don't believe that it is proper to proceed at this time.
I mean, it sounds to me, obviously that you were aware of certainly that position on behalf of your client before this morning. I'm just curious as to why you wouldn't have filed a motion to dismiss based on the fact that you hadn't received a proper, copy of the verified complaint.
Well, we filed an answer, and we filed an answer by special appearance, so I don't know if that's something that all of the members of the commission have been provided with, but we did file an answer attempting to provide as much information as possible to the commission for this issue, but obviously if the statute has not been met by the investigating entity, then we don't believe that there is any proper way to proceed at this time.
Mr. Baywell, do you have a response with regard to the service of a certified complaint?
I don't necessarily think that's her issue, but the complaint was served on Nathaniel Darnell. He's the registered agent for GRA Inc. I think what she's getting at is the form for third-party complaints. A complainant under oath has to submit the third-party complaint form. That's statutorily required. We have our own rule where it specifically excuses commission staff from having to certify under oath. And essentially, our viewpoint on that is when I affix my signature to the complaint, I am asserting and affirming that I have reasonable grounds in fact and law in proceeding.
May I ask this, or if I understand, excuse me, over here.
Yes, ma'am.
So do you agree that the service should be made under oath? I'm not familiar with the statute, but you're saying that your signature on the paper would constitute a verification or constitute an oath?
We have a rule that specifically addresses this, and it specifically says, our rule essentially goes through the third-party complaint process where the oath is required. And that's a third party, a civilian, that fills out a form and files a complaint against another respondent. In our rule, it outlines the steps required for a third-party complaint. And then our rule says, and don't quote me verbatim, but our rule says something to the effect that those requirements for a third-party complaint, the oath, the verification, are not required by commission staff when we generate a complaint. And this was a commission-generated complaint.
That was the distinction I was trying to understand, whether it's not required that it be under oath, or that it is required, but yet your signature constitutes that. Because I had understood you to say by signing it, it constituted a verification. So I'm trying to understand that distinction.
I think that is how that's our intent, or that's how we interpret that rule, and why we don't, as commission staff members under oath, sign. We don't go to a notary, and we don't take an oath when we file complaints. And that's been how we've done it on every commission-generated complaint since I've been here, and I'm sure it's been that way even longer than
So
that.
it's your position it wasn't required to have been under oath?
Correct.
Well, and if I may respond to that, it does appear that the initial complaint against the GRA PAC was made according to the statutory requirements, which would of course supersede any rules made by a commission. So it does appear that under appropriate circumstances, that they do make the statutorily required written complaint, which verifies under oath to the best information, knowledge, and belief by the person or staff attorney making such complaint. So I'm not sure, perhaps Mr. Biowall might be able to cite the rule that he doesn't wish to be quoted on, but according to the statute of the Official Code of Georgia annotated, even a staff attorney is required to undertake this particular important verified step.
Well, I assume this is the rule that you are citing to, Mr. Baywell. It's 189-2-.04, initiation of investigations by the commission. It says commission staff, when it discovers or learns of evidence that a violation of the Georgia Government Transparency and Campaign Finance Act or any other statute within the jurisdiction of the commission may have occurred, may initiate on reasonable belief that probable cause exists an investigation into suspected violations of laws or rules under the jurisdiction as it deems necessary. In such case, the applicable procedures found in Rules 189-2-.03, 189-2-.05, and 2-.06 shall be followed in the investigation. The respondent shall be notified by the commission staff in writing of the initiation of the investigation and of the basis for the filing and probable cause to open the investigation. The commission staff shall not be required to file the complaint form described in Rule 189-2-.031, nor to follow the procedures required by that rule. Is that right?
Yes, sir, and I will also correct that I signed the complaint that originally went out on GRA PAC LLC. That was not a third-party complaint, and that complaint wasn't under oath. And
Okay.
nothing of the form of this complaint has deviated from any complaint that I've ever done in my time here, sir.
Okay. Ms. Bernard, any other preliminary matter before we hear from Mr. Baywell?
Just that we would remain operating under the statute 215610A, which does specifically require a staff attorney for the Ethics Commission or a staff-initiated complaint to engage in this specific administrative process for purposes of verification.
Okay, your objection's noted. Mr. Baywell?
Thank you.
Yes, sir. And I will forewarn the commissioners that there's a lot of moving pieces and a lot of players in this
Mr.
case.
Chairman, can I make a personal privilege?
Sure.
Mr. Baywell, you're a good bit taller than Mr. Knittel. Would you be kind enough to lift the microphone? And Ms. Bernard, without conceding any of your arguments on jurisdiction, would you be kind enough to use our microphone if you have anything further to say?
certainly didn't want to push the staff attorney away from the.
That will not be deemed an admission or submission to jurisdiction, at least by me.
Thank you very much.
And it would be graciously appreciated.
Certainly.
And Ms. Bernard, I won't bite. I will forewarn the commissioners that this is a pretty voluminous case, a pretty voluminous investigation. I'm somebody who's had the benefit of looking at all this material for the last 5 months. So when I see things, I probably have a different viewpoint than you will, just hearing this fresh today. So bear with me. I know when I was preparing this PowerPoint, things that I was putting in slides made sense to me, but while I was preparing it, I'm more than appreciative of the fact that I have a different vantage point than you will. So bear with me. A lot of the information that I'm going to present might seem small at first, but this is one of those big picture cases where, you know, the details will matter in the end. And they might not be clear immediately, but I just ask for some patience with that regard. How this case originated.
And I'm gonna actually stop you quickly, just for a moment. Are there ways for us, and I know that you put a lot of time into this, is what you just said, but is there any way to address jurisdiction first and then go into the substantive allegations?
Yes, I can do that.
Okay.
And I did file a brief in support, and in part, I did address jurisdiction. And I think the commission, there's no categorical jurisdiction to where the commission can just say, this group of people is not subject to the Ethics Commission jurisdiction. This group of people is. I think this is a fact-sensitive analysis, and when I'm done with my PowerPoint, I think there's going to be sufficient facts where GRA Inc. fits within statutory definitions, and they fit within our jurisdiction. This case originated probably late June or early July this past summer, and this stemmed from an alleged Ponzi scheme that occurred in Noonan, Georgia. And two of the members that were involved in that allegation, Brant Frost IV and Brant Frost V, they ran a series of organizations, First Liberty, First National. Just when I discuss them, I will probably collectively refer to them just as First Liberty, but there's more entities involved, but they're all interrelated and affiliated. And other agencies contacted our office because First Liberty was a sizable donor to an organization called GRA PAC LLC, and the LLC was originated by Brant Frost IV. So our original scope of this honestly wasn't for a complaint. Our role was to try and look at GRA PAC LLC's reports. They were registered as a political action committee with the commission. They were filing reports, and we were just trying to trace the money. We were trying to find out dates, times, amounts of First Liberty money going into the PAC. We were trying to see if we could see destinations of that money to, really, there was a receiver that was appointed, and we were just trying to get as much money as we could, or let other agencies know this is the information we have. Maybe talk to these people about recouping some of that money. The original focus was just helping out and doing what we can to try and get people that were victims of this alleged Ponzi scheme made whole. When I started reviewing GRA PAC LLC's reports, and again, they were registered as a PAC, I saw activity that was consistent with a PAC. And a PAC is an entity that raises funds and distributes that money directly to candidates. So on a CCDR, you'll see expenditures to individual candidates or individual candidate committees. While I was looking at the reports, I saw anywhere from 10 to 15 consultants or other vendors, third-party vendors, which in my training and experience, that's not necessarily PAC-related activity. It could be a nonprofit that's just reporting expenditures that are occurring out of the account, but aren't necessarily going directly to candidates. But that was something that was noteworthy to me, because typically, a PAC CCDR, you're going to see contributions and expenditures directly to candidates. You're not going to see expenditures to third parties, consultant firms. In mid-July, I tried to track down the addresses for as many of those third-party vendors as I could. I sent out subpoenas to all of them, and as I started receiving information back on those subpoenas, it became clear to me that GRA PAC LLC was actually a hybrid organization, meaning it functioned as both a political action committee and an independent committee. And the distinction between the two, an independent committee raises funds and they spend that money on behalf of candidates, but they don't coordinate with those candidates. And those are independent expenditures that they're making. Typically, you'll see organizations, independent committees, they'll do mailers, they'll do interactive things online, they might do billboards, radio ads. They identify themselves as an independent committee and they make those expenditures, and that's what their CCDRs look like. Under our rules, and even under our statute, political action committees and independent committees are two separate things. There's separate registrations, there's separate filings, separate filing dates. So when an entity engages in both, we have this advisory opinion that addresses it, and it's, you know, a fair reading of the statute. The entity has to register as both a PAC and an independent committee. So the original complaint went out, in this case, July 30th, 2025, and that was against Georgia Republican Assembly PAC LLC, and it was those violations as an independent committee. While I was investigating that, and there were other complaints that stemmed from just following this money trail. Georgia Freedom Fund was another organization, and that was a consent order that this commission adopted at the September commission meeting. While I was investigating that and following the money, I did come across information on how GRA Inc. and GRA PAC LLC were interconnected or intertwined. And originally, my understanding or my belief was that they were serving as a connected organization. GRA PAC LLC used the name, and that naming requirement is something in our statute, that a connected organization that establishes or administers a PAC, that PAC or independent committee, that name has to be referenced. It's a transparency thing. So voters know the corporate interests that are behind these PACs and independent committees. And just the more information that was coming in, I was looking at social media a lot. GRA Inc. is pretty active with, they're a grassroots organization. Their goal is to enhance constitutionally conservative policies throughout Georgia. While I was looking at all this information, they were putting out resolutions, they were condemning the Frost family, they were distancing themselves from GRA PAC LLC, understandably. And this case has nothing to do with GRA Inc. and the Ponzi scheme or anything like that, but just the more information that I came across, I saw a lot of very strong connections. So I continued investigating. I served a subpoena on GRA Inc. and they complied, asking for certain documents. I can tell you this case, I probably reviewed over 1,000 pieces of evidence, some material, some not. After my findings, this was something that was discussed in office, and this is something that we talked to corporate attorneys on. This is something I talked with Ms. Young on, and she was very helpful. We looked at the law, we looked at prior precedent, and we think we have facts for jurisdiction, and we think we have facts for reasonable grounds. The defenses in the response from GRA Inc., to boil it down, they raised 3 defenses. They raised the statute of limitations defense, and some of the charges that we have are outside the 3-year period. I would submit that this is a case where we would ask for equitable tolling or estoppel because we weren't on reasonable notice that these violations were occurring. The reason we weren't on notice is because GRA PAC LLC registered as a political action committee, and we weren't on notice that there was any independent committee activity going on. I will say too, we've spent $1 million on a filing system so we can get notice when violations occur. And a key piece of that, in order for us to be on notice, is entities have to follow their legal duties, and an independent committee has to register. If they don't register, we reasonably can't go intercept mail at the post office and try and determine, who's a PAC, who's an independent committee. So for the statute of limitations defense, yes, some of the violations in this complaint are outside of that 3-year period, but we think we have good grounds for equitable tolling of the statute of limitations and estoppel from respondents raising this based on those actions. Another thing I can add too, in the grounds for that, when you're registering as a PAC and you're actually an independent committee, that online registration in our statute, you're affirming the accuracy of that information. So if you're not registering, you're signaling to us something different. You're concealing a material fact, and in part, it's even fraudulent. So that would be our response on any statute of limitations arguments. Jurisdictionally, again.
Mr. Baywell?
Yes, sir.
Interrupt you again, I apologize. So I'm looking at the alleged violations here.
Yes, sir.
Again, I've got, and I appreciate you breaking them down so that we can talk about them by number. With respect to those statute of limitation issues, so is it 2 through 7, or is it just 2 through 4 on that first set? Do you know? Sorry. I just want to make sure that I get this noted where we're breaking those issues down.
And Mr. Chairman, could I be directed to the statute of limitations?
I'm sorry?
Is that in the packet?
What?
I'd like to
She's
see
asking
the
about what?
statute,
Yeah, sorry.
The statute of limitations?
yes.
In our statute,
Yes.
The one that we're talking about is 3 years.
off the top of my head, I think it's 21.5, somewhere in the teens, maybe
Okay.
16.
It's,
And the rule on that is,
it's 21-5-13,
13.
and the statute of limitations will differ based on the type of entity. So, for example, a campaign committee that serves a 4-year office has a different statute of limitations than a campaign committee with a 6-year office. And that differs from an independent committee, but the statute of limitations is contained within 21-5-13.
I was sort of interested just in the language, because if you're talking about tolling,
yes.
you're talking about fraud that prevented you from complying with the statute. I wanted to see what the word said.
That's not specific in our statute, and I would, off the top of my head, I would say it's Title IX in the official code of
Okay.
Georgia. But there are separate sections that deal with fraud, concealment of fact,
Right.
and I think we would be on pretty good grounds here based on the fact that there was no registration. Now, Mr. Chairman, to your question, violation 1 should have occurred outside of the 3-year period. The first instance or expenditure that I noticed in this complaint was from August 6, 2020. So registration should have occurred at least by that date.
Okay.
And then,
What date was the complaint filed?
So against GRA PAC LLC, it was July 30th, 2025.
So,
Men-
Mr.
men-
Mr. Chairman, to your question, I believe it would be 1 through 6.
That's what I thought.
Would be the ones that would be, I guess, exempted by the tolling provision. The others would be within 3 years.
And also 17 through 36.
That was my next question. Okay. Okay, thank you.
So that is our position with respects to the statute of limitations argument. The last argument that they raised, a series of 2 arguments that GRA Inc. is a separate legal entity, and they argued that GRA Inc. lacked control over GRA PAC LLC. And to that, I would just argue that the Campaign Finance Act, and especially if you just look at the plain reading of the definitions in 2153, it seems to be broader than just focusing on individual entities. So I do believe we have a basis to proceed on those grounds too.
Mr. Baywell, why are these 2 not separate cases? I'm a little confused how, it's the same case number, right? And we have half of the respondent, waiving preliminary, but we have the other half we're arguing about. How come they're not separated? And
I think just from an efficiency and an economy standpoint, there were the same 50 charges that we're seeking to hold them as violators on. I would compare it to an armed robbery with a driver and a principal who goes into the liquor store. You'd never, file 2 separate charges because you're going to have the same
so
witnesses.
it's a legal mumbo jumbo, you're saying?
I wouldn't say legal mumbo jumbo. I just think it makes the most sense.
I find it hard that we're gonna go forward with this, and one person's already saying, okay, we'll just waive the preliminary, but we're still using the exact same thing to go after somebody else, that another entity that you say are connected. So that's my confusion, but if there's a legal reason for it, I'll trust you.
No, I understand. It makes sense. Common witnesses, common charges. In theory, I can get up here and talk for an hour and a half as it relates to GRA PAC LLC, and then we can come back after lunch and I can talk for another hour and a half and make the same arguments.
Well, we don't have to do it for one of them because they've already waived.
Well, and I understand that, and I will tell you, I also have evidence of the substantive violations. So that stipulation only pertains to the LLC. I will present evidence substantiating all the charges as it relates to the Inc. Just a listing of the violations, and again, this is something that I believe was in the packet on the notice of violations that was filed. And there's 3 different categories. Violation 1 is simply the failure to register. Violations 2 through 16 are failure to file the disclosure reports. Violations 17 to 50 are the individual independent expenditures that were not reported. And we're proceeding on those 50 allegations today. The starting point, again, 2153, this is just our basic definitions, and I think this gets us pretty far down the field in terms of jurisdiction. An independent committee means any committee, club, association, partnership, corporation, labor union, or other group of persons other than a campaign committee, political party, or political action committee, which receives donations and spends them to advocate on the election or defeat of a particular candidate. And I think the pivotal wording in this is association, partnership, or other group of persons. And when you look at how the code defines a person means an individual, partnership, committee, association, corporation, limited liability company, limited liability partnership, trust, professional corporation, etc. So just a plain meaning of the definitions of our statute. 2 independent entities or an LLC and an Inc. that filed separately with the Secretary of State can make up the other group of persons that forms an independent committee, and they can make up the other group of persons that forms a political action committee. I did touch on this, and it's listed, I'll just go over it briefly in the slide, but advisory opinion 2015-02. Again, this was just an advisory opinion that addressed registration and reporting for hybrid organizations, PACs and independent committees. And going back to 2015, we've advised that you have to register and meet the reporting requirements for both entities.
May I ask one question?
Yes, sir.
I guess this same question would apply to, say, the Democratic Socialists on the other end. They are not, there's a definition of what a political party is that they don't meet. Is that?
I'm not sure I understand your question.
Yes. Yes.
An independent committee excludes a political party.
Political party is defined in Title 21, Chapter 2. And there's a specific definition, which, to your example, the DSA qualifies
Okay.
as a political
I
party.
didn't mean to confuse, but
Yeah.
they're not a party under our statute. Okay. Thanks.
The applicable law in this case, 21-534F, and this is the registration and filing requirements for independent committees. Section 1 requires that an independent committee register with the commission prior to accepting contributions or making expenditures. So that would be pertaining to violation 1. The disclosure report filings, those are due the first day of each of the 2 calendar months preceding any such election, 2 weeks prior to the date of such election, and then within the 2-week period between the last filing and the election, the 2-day reports become due. In addition to that, the June 30th and December 31st supplemental reports, those have to be filed. Now, this is not a crystal clear, well, I shouldn't say it like that, but this is our interpretation of this. An independent committee automatically is going to have to file June 30th and December 31st of each year they're in existence. What triggers the reports on the first day of each of the 2 calendar months preceding the election and 2 weeks prior to the date of such election is actual independent expenditures. So if I gave you an example, let's assume a primary election is May 25th. The 2 months preceding May 25th, March 1st and April 1st are reporting periods. If before March 1st you're not supporting or opposing any candidates for the election, you wouldn't have a legal duty to file that CCDR. Same thing for April 1st. If prior to April 1st, if you don't have any independent expenditures, you're not supporting or opposing a candidate in an election, and you don't have that legal duty to file. Same thing with the 15-day reports. So when I say there's a lot of moving pieces to this, I can't just go back to 2020 and say there's, 4 reports for every primary and 4 reports for every general election that are due. In fairness, and our interpretation is this, you have to make sure there's an independent expenditure for that reporting period. If there's not, they technically don't have the legal duty to file those. So if you see that the second batch of violations for the disclosure reports are scattered, that's the explanation. I can't just go, there's 8 reports due in 2020, 8 reports due in 2021. I actually have to go find independent expenditures that would trigger those reports. The last legal section of this, and this pertains to the 3rd category of violations for not reporting the individual expenditures. Again, it's like most disclosure reports, you have to report and identify expenditures over $100. You have to include the name, address, occupation, and employer. Another caveat to this, and this is a big reason why just simply filing PAC reports is insufficient, you also have to indicate who you're supporting or opposing. And that's another big transparency thing for voters. So, when voters see commercials on TV or when they get mailers coming home, they know the corporate interest that's behind those mailers. They would have access to the contributors of the independent committee. So that's the third category of law that I believe is relevant for the third category of violations. There is commission precedent for finding, two entities liable for violations of the act. Most recently, New Georgia Project, Inc. and New Georgia Project Action Fund, Inc. And that was a case that was handled on the same complaint, Mr. Thompson. Similar facts, I'm not going to say it's the same facts, but you did have New Georgia Project, Inc., which was registered separately with the Secretary of State. You had New Georgia Project Action Fund, Inc., which was registered separately, but that was a case based on the circumstances, a lot of similar circumstances here. We believe that both of those complainants, or both of those respondents violated the act. I will say that I can't hide from this, they both operated out of the same bank account. And I can tell you in this case, GRA Inc. and GRA PAC LLC had separate bank accounts. So that's a factor that would cut against us. But common control, is a huge factor. And again, this goes back to the definitions in 21.5.3. We're not just looking at an entity and saying you're violating, because it's possible that two entities form the association, partnership, or other group of persons. I will say too, that case resolved by consent agreement, that was litigated. The commission knows there was, a recognized local election attorney working on that. There was federal attorneys in DC, a reputable firm working on that. So that's not a complaint that we just jammed through the commission. I found older case precedent, and this is, I didn't have, I wasn't able to access files or anything like that, but you could tell just on how those consent agreements were written. You can tell that the commission, this isn't a new thing. We've been imposing liability on separate entities or an entity for different entities' violations going back over 20 years. The last thing in all of those consent agreements were in the brief that I provided in advance. This case wasn't. We didn't necessarily have a consent agreement on this, but the Oxendine matter. And we have a fuzzy recording, and it's a long recording, and it's not great, but I definitely know, Mr. Chairman, this is an argument that you made when the commission was contemplating sending this complaint back to OSA. And the argument that those specific facts, Mr. Oxendine received, there were 10 political action committees that maxed out donations, and it appeared to be the same person, same dates, same checks, things of that nature. And Mr. Chairman, that was your argument that, OSA gave us a negative decision, and your consideration on remand is you said, wait a second, that's a pretty fair and reasonable reading of 21.5.3, and that wasn't considered. So I'm not, I have commission precedent stability for proceeding in this case. The evidence in this case, violation 1, it's not something that I can document easily, but it would just be the absence of an independent committee registration on our filing system. Violations 2 through 16, again, stem from that. You have to be registered on our filing system in order to file the CCDRs. Violations 17 through 20, these are the independent expenditures that I identified from GRA PAC LLC's financials. And the way they correspond, for instance, this slide corresponds with violations 17 through 20. The check in the upper left-hand corner, Steadfast USA, that's 17. If you go down in that column, Mobilize the Message LLC, the check number is VV012, that would correspond to violation 18. Moving up to the upper right corner of the screen, that would correspond to violation 19, and the lower right corner, that would correspond to violation 20. And that's the format for the next series of checks that I'm going to be going through. If the commission wants to cross-reference those with the complaint, I can slow down on this. If it's something that I could move through a little quicker, I'm also happy to do that. Keep it moving.
Keep going, yes.
Violations 20 through 24, again, these 4 series of checks correspond with the expenditures as alleged in those violations. Violations 25 through 28, again, same series of checks. Violations 29 through 32, same series of checks corresponding with those violations. Violations 33 through 36. Violations 37 through 40. Violations 41 through 44. Violations 45 through 48. And violations 49 and 50. And those are the individual expenditures that I observed coming out of the GRA PAC LLC account. And again, drawing it back, when you're looking at PAC activity, you're going to see a check made out to Tim for House District 5. You're not always, I mean, definitely a nonprofit could have other expenses that aren't necessarily independent expenditures, but when I saw the filings, when I saw checks like this definitely was something that stuck out to me that I need to do some further investigation. I didn't match invoice per invoice, and I can tell you some of the checks that were written covered, multiple mailers, so I didn't match, check per mailer, and it's a little confusing to do. But for instance here, this is a slide of mailers that were sent out. These were purchased from American Campaign Services expenditures, and these would coordinate with the series of checks that were presented for that consulting firm. These are a series of internet banners that were purchased from American Campaign Services expenditures. If you note too, these have Georgia Freedom Caucus, that logo on these. I don't want to misspeak and talk about the relationship between Georgia Freedom Caucus and GRA Inc., but I think there's some connection. There's definitely some overlap in people involved in both organizations. There's overlap in candidates that both support. There was overlap in the fact that Georgia Freedom Fund sent over money to GRA PAC LLC. These were purchased. I think there were funds, again, that were sent back from GRA PAC LLC back to Georgia Freedom Fund. So just to explain that detail, there is some connection, not saying legal connection, not saying they're a partnership or anything like that, but you see a lot of overlap between Georgia Freedom Caucus members and candidates that GRA Inc. endorses. 2 other mailers that went out from American Campaign Services expenditures. These are local school board races in Coweta County. I will add too, there's 4 candidates in the advertisement on the right, Britton, Gambardella, Menk, and Smith, and there were multiple mailers with the same format on the left, but some of the mailers differed, meaning one had Menk on it, one had Britton on it, one had Gambardella on it, and I omitted those just for trying to be efficient because I recognize this is a pretty voluminous PowerPoint. Print Source was another vendor. We served a subpoena on them, they complied. These are some of the mailers that went out. These are mailers that are endorsing Charlie Chase for the House of Representatives. He was in a special election in, I think it was 2023, yeah, 2023, and then he advanced to the runoff. These are more expenditures from Print Source. Upper left is Charlie Chase. Lower left, Gene King, he was a candidate for Meriwether Commission. There's a negative ad on Dale Washburn. There's another advertisement from Georgia Freedom Caucus. That does indicate to paid for by GRA PAC. That does feature a candidate, Charlize Bird. She's somebody who's involved with GRA Inc., or they're supported or endorsed. More Print Source expenditures. Minuteman Press, these were the graphics that we got from them. And again, we're getting these, so we're not just relying on the checks to say these are independent expenditures, you're an independent committee, you need to register. We're, looking at the actual graphics and making the determination you're supporting or opposing a candidate for office, you are an independent committee. This was also Minuteman Press. These were 3 candidates for the Coweta School Board. Landmark Communications, they responded. There were a couple mailers that went out. You can see the graphics for those. Robert Bob Smith, he was endorsed by the GRA. They also did a calling plan, and you can see the script that was used for that to endorse Bob Smith. Hazlitt Industries, there's no graphics to this. This was door knocking and canvassing. You can see this specific receipt was for Charlie Chase. I think there are others, and I think I have records too, where they were breaking down the days they were knocking on doors. Some of that stuff I didn't include just because I didn't believe it was immediately material for this proceeding. But I do have additional information, and I want to make that clear. Mobilize the Message is in the same category. It's some polling and door knocking. Stone Ridge, this is another mailer that went out, and this was another vendor that one of the checks went to. I don't believe I got a complete return on this, and I believe there's a management company that just started after some of the expenditures occurred, and they didn't have all the records that I asked for, but this is what they provided. And that is the substantive allegations and violations 1 through 50. Now, this is probably what the ink has been.
Let me ask a question if I can.
Yes, sir.
These expenditures were by the PAC as far as you could tell.
They came out of the PAC LLC bank account.
There were no checks or wires from the GRA itself.
Correct.
We're relying on what you're about to get into in part 2.
Yes, why I think this is bigger than just GRA PAC LLC.
But these were all paid by PAC checks or PAC.
Yes, sir.
Okay,
And Brent Frost V, he was the signatory on the GRA PAC
I've heard of it.
LLC account. He was also the vice president of GRA
Right.
for several years.
Thank
So
you.
now the meat and why is GRA Inc. here? And again, this wasn't a hasty decision. You could see from the procedural history, we weren't even really looking to target GRA PAC LLC as a respondent, and it just, after gathering evidence, it was clear that there were some violations. GRA Inc., same footing, just going through Facebook, social media, Twitter, things that they're putting out, their website, archives of their website, emails, communications that they put out, just after going through a lot of that stuff and memorializing it, that's when the decision was made that they should be added to this complaint. This is the bylaws for GRA PAC LLC. And I got this copy through a subpoena on GRA PAC LLC and Brent Frost V. And the information that was conveyed to me, these were the original bylaws. And this organization actually organized in 2017. We rely, for this complaint, we just focus specifically on our filing system. But GRA PAC LLC originated in 2017, just to be clear. Some of the things that I've highlighted on the bylaws and which I believe show association, partnership, or other group of persons, I'm not saying this alone is it, but I have a feeling we're going to have, there's a lot of cherry picking, and at the end of this, I think we're going to have a pretty full bushel. But some of the things, GRA PAC, this is a better one for me. Purpose to identify, recruit, support constitutional conservative candidates consistent with the GRA platform. The 1.3 limitations, there is a board of directors, and I'm going to get to the board of directors and why I think some of those directors are problematic. But limitations, no funds may be voted on for any item without the approval of 2/3 of the board of directors. So board of directors are controlling this. Originally, a lot of information came out that this was the Frost family PAC, or Brent Frost V alone was controlling this, and I believe that information to be false. So the composition of the board of directors, I think, is very relevant in this case. Membership for GRA PAC, it's starting to look like a closed shop. Members must be a member of the Georgia Republican Assembly. Candidate endorsement, board of directors shall review qualifications of candidates. So even before anything is put to members, it goes through the board of directors first. So this isn't operating independently. There's a group of people that are controlling who the members are, where the money's going. Candidate endorsement, and again, these are the original.
Any reference in these bylaws to GRA just by itself? There's a reference to it, right?
Yes, so
if they're referring to the PAC, it's always GRA-PAC.
yes.
Okay, I just want to make sure that everyone understands that any reference to GRA just by itself is a reference to GRA Inc.
My interpretation of this is when they say, you can see, for instance, membership in the GRA PAC, you must be a member of the Georgia Republican Assembly. My interpretation of that is you're a member of Georgia Republican Assembly, Inc.
Okay, that's exactly what my question was.
Yeah, that's my interpretation. Candidate support, it's not an exclusive prong. You can see that there's 5 factors they look at, and I think you have to meet 3 of the following. But one of those factors is you have to be a member of the Georgia Republican Assembly. So again, closed shop on membership, closed shop on donors, starting to look pretty close to a closed shop on must be a member of the Georgia Republican Assembly to get candidate support, financial support as an endorsement. I'll also note too that those candidates that are getting money, if they are members of the Georgia Republican Assembly, they are paying dues to the Georgia Republican Assembly. So there is some financial overlap between at least that aspect of it. More powers of the board of directors. They may appoint, they may remove at will. Quorum, I highlighted 50% of the board of directors. That's going to become a little bit more relevant on the next few slides. But again, this is something that, me seeing the case as a whole, when I see something like this, there's other triggers that I have when I see this. So this is a little bit interesting here. This came from an email that GRA Inc. provided, and Mr. Nathaniel Darnell sent me a bunch of responsive documents. And a lot of those documents were emails that went out that either mentioned GRA PAC or, he believed to be within the scope of my subpoena. The email was sent September 14th, 2020 by Brant Frost V. And again, I actually saw this before I saw the original bylaws that we just looked at. But again, early on in this complaint, July over the summer, relying on a lot of things that GRA Inc. is putting out, I'm thinking that we have a one-member LLC, it's Brant Frost V. So this was surprising to me even to see that there were actual bylaws and there were actual board of directors, because that aspect conflicts with a lot of statements that GRA Inc. has made. And we're going to get to those at the end of the PowerPoint. These amended bylaws, I have tried to get to the bottom of this. I have talked to some of the board members and I'm not getting great responses from them. I did finally serve a subpoena on GRA PAC LLC and Brant Frost, and I asked for a copy of all bylaws. He didn't produce this. And I went back to his attorney, Mr. Sabatini, and I said, well, wait a second. Just looking at markups on bylaws, you can infer that there's a prior version, and you can at least infer there's a secondary version of bylaws. Why isn't he turning this over? And the answer that I just got is he only has the one set of bylaws. So there's something fishy going on, and this is probably, to be honest with you, this is probably a complaint where we need to start getting board members under oath, and we need to start getting answers. But I will caution, this was an email, again, there was a link on the email, and I'm somebody, if I get discovery, if I get records in an email, I'm gonna click every link that I can. And I can tell you on some of these emails, they were dead links, the web page doesn't exist. Some of the links that I clicked, I did actually get documents, and this is one of them. But when I first saw this, again, this is, maybe in August, or, no, I'm sorry. Mr. Darnell complied with the subpoena maybe around September 15th. But this was something that just stuck out, because prior to this, I've been operating on different facts that GRA Inc. was portraying. When you look at these markups, this goes a little bit deeper to identify, recruit, and support constitutional conservative candidates consistent with the GRA platform through principled fights and confrontational politics while supporting the GRA. And my interpretation of that is they're referring to the Georgia Republican Assembly, Inc. So now you're kind of cementing bylaws that are lacking independence. This isn't an independent political action committee or independent committee. This is somebody that's supporting the GRA. So when we're talking about association, partnership, or other group of persons, I think that's a fairly strong piece. Limitations, allocating funds without the approval of 2/3 of the board of directors. So the board of directors on this is going to become relevant in the next couple of slides. Supporters, a supporter of the PAC, and then the board of directors have the decision-making authority on who's a supporter and who's not. Candidate support requirements, again, must be a member of the Georgia Republican Assembly to receive candidate support. So again, this is operating like a closed shop. One of the other arguments I made in this complaint too is there may be an alter ego theory of liability. I think it's secondary to a plain reading of our statute, but if you have GRA and then GRA PAC, which is so dominated that it can't take money from outside of GRA, they can't give out money outside of GRA, I think that's a pretty fair alter ego argument that there's no independent existence. And use an example. Say Waffle House decides they want to start a PAC, and you have a board of directors with Waffle House who knows how to make delicious waffles, they know how to sell them, they know where to sell them. They decide to start a PAC. You know, they're not gonna create a board of directors for their PAC that knows how to make waffles or knows how to sell waffles. You're gonna have people who know how to raise and spend money on campaigns. And this case isn't, you know, every connected organization is automatically going to be liable for actions of their PAC or actions of their independent committee. But you can see Waffle House's PAC, you can see independence built in, and that's something that I don't see with GRA PAC. Another thing, if you think of, you know, independence, and is this really an independent political action committee? Maybe the best interest of a political action committee is to raise money outside of just a specific group. Maybe an independent political action committee or independent committee, maybe they get more access or influence if they support more candidates. Maybe there's a fringe candidate that GRA Inc. doesn't like, but an independent board should have that authority to say, you know, maybe it's in the best interest of the LLC if we have this autonomy. And I don't think that exists in this case. Board of Directors selection and term, 4.4 on this. The Board of Directors shall be composed of 11 directors. You can tell, in my opinion, somebody with corporate know-how is working on this and doing these write-ups. And 11 directors, I can tell you right now, the argument's going to be, you know, if Alex Johnson or Nathaniel Darnell happens to find their way onto the GRA PAC LLC board, the argument's going to be, well, I didn't have any control. I was only, 9%. I will say also, I've never, out of the people I've talked to and out of the documents that I received, I've never seen more than 7 GRA PAC LLC board members. But that was something that was noteworthy to me, just having access to more information than the commissioners are too right now. And I included this just for completeness, and it's something that if, commissioners have PowerPoint packets, they can refer to. But off the top of my head, I don't recall anything noteworthy on this. Again, when I received this, these were all in response to the subpoena that I served on GRA Inc. And again, before I received this subpoena, I'm operating on, this is Brant Frost's thing. I'm relying that the information that GRA Inc. is putting out is reliable. So when I saw stuff like this, I will say it was I don't want to say bombshell, but it was something that I said I need to put a pin in this because something's not right here. This was an email that Brant Frost sent. You can see Nathaniel Darnell. In a few slides down the road, you'll get a better idea of who the characters are in this. But 2017-2018 GRA PAC Board of Directors, you can see 5 names that are highlighted: Kay Godwin, Pat Tippett, Brant Frost, Alex Johnson, and Jack Staver. So 5 of the 7 are highlighted, and we'll get to those because the evidence that I have is those are dual directors. So this board is dominated by GRA directors. GRA directors have a fiduciary duty to GRA. They have a duty of loyalty to GRA. So definitely I'm not a corporate law expert, I'll candidly admit that, but when you're talking about control, when you're talking about needing 50% for quorum, when you're talking about 2/3 requirements to spend funds, and 5 of your 7 directors have a conflict, I think that's pretty noteworthy and pretty problematic. The slide on the right, the roster of 2019 to 2020 GRA PAC Board of Directors, same names are highlighted. I will caution that somewhere around 2019, I think it was later in 2019, the way GRA's bylaws work is they have elected officers every 2 years, and they become part of the board of directors for GRA Inc. It's not the entire board. We'll get to that a few slides later. But also, I did talk with Kay Godwin via email. I talked to her son over phone, and he indicated to me that Kay Godwin and Pat Tippett were also honorary board members. So I'll, place that caveat there. I don't think they were elected officers. From memory, I think their convention, when they elect their officers in 2019, was later in the year. So parts of 2019, they definitely could have been on GRA Inc.'s board of directors, or again, executive committee. I will get to the bylaws in a little bit, but I'm noting that. There's still a possibility that they're honorary board members, and somebody that I talked to specifically told that to me. 2021 to 2022, another roster of GRA PAC board of directors. Again, there's 5 now of 6 names that are highlighted. Brant Frost V, Nathaniel Darnell, Pat Tippett, Alex Johnson, and Kay Godwin. And they're highlighted for positions they have with GRA Inc. As part of the subpoena, I served on GRA PAC LLC and Brant Frost and his attorney. One of the things that I requested was the name and contact information for any board member of GRA PAC LLC. He provided an Excel document, and the lower right-hand corner of this PowerPoint slide, that's verbatim copy and pasted from what he provided me in Excel format. You can see the names that he lists: Pat Tippett, Kay Godwin, Brant Frost IV, Brant Frost V, Jack Staver, Nathaniel Darnell, Alex Johnson, and Paul Brown. He also has dates corresponding with those names. So at certain points, there were 7 board members, and then post-2021, Jack Staver was, according to Brant Frost V, Jack Staver was no longer on the GRA PAC LLC board, and Paul Brown, he left in 2021. This is from GRA's website. This is their elected officers, and I do have snippets from their bylaws. Again, they have elected officers. They're elected, I believe, at their conventions every 2 years. And this tab, so the picture on the left that has the 8 pictures, they're not mugshots, but photos, professional portraits. That tab, you can see leadership 2014 to 2019. You can see Alex Johnson's name's highlighted. He's a dual director. Pat Tippett, dual director. Kay Godwin, dual director. Jack Staver, dual director. Brant Frost V, this was recovered from the website archives. This was actually scrubbed from GRA Inc.'s website. But you can see 5 of 7 of GRA PAC's board are GRA directors. 2020 through 2025, again, this is the period where it's possible just 3 of 6 were dual board members, but I would say I did get information that Kay Godwin and Pat Tippett were honorary board members. I will say the conversation I had with Godwin over email and the son, on that specific detail, I didn't press him on whether they were honorary board members. That was volunteered to me. But like I said, this is a case where I think the commission needs to start getting people under oath, and we can really hash out what this board composition looked like. But for certain, Alex Johnson was the GRA president. Nathaniel Darnell, back in 2020, he was the 3rd vice president. He's climbed the ranks since. I haven't specifically noted each position he's held, but it's my belief that he's been an elected officer with GRA from 2020 to 2025. He's currently the president of GRA. Brant Frost V, 1st vice president again, and my understanding is he was the 1st vice president until around June of 2025.
Mr. Bigwall?
Yes, sir.
I hate it. Well, I'm not going to say hate. I don't like it when someone asks me how much longer you think you may have. I just need to check with the commissioners. to be sure that no one needs to take a break? Is everyone gonna be okay? You've got about, what, 30 more minutes or so? I mean, I know.
I will try, I'll do my best. I think when we get past this, more of it's gonna be like Facebook postings, stuff like that. And I have tried to highlight the relevant materials.
Again, I do not want you to think I'm trying to rush you. I promise I'm not. I just want to make sure everyone is
I
comfortable.
appreciate you asking. I wouldn't mind a 5-minute break.
Okay, let's take a quick 5-minute break. You to good stopping point?
Yes, sir.
Okay, we'll take a 5-minute break or so. Order, Mr. Babel, you can pick up where you left off.
Thank you, sir. Next slide. This is just some snippets I had from the GRA bylaws. There's a little disclaimer at the bottom right. I did find a set of bylaws active as of December 2021. I think there were 2 other versions too, 2024 and 2025. There are some changes between bylaws, so I don't want to, state that the December 2021 bylaws are still relevant. I also don't have any bylaws prior to 2021, and I didn't ask for those yet either. But some sample sections, which the materiality between 2021, 2024, and 2025 is the same. But again, GRA Inc.'s bylaws, section 5.01, elected officers. The elected officers of the Georgia Republican Assembly shall be the president, first vice president, second vice president, third secretary, assistant secretary, treasurer, and 2 national directors. Executive committee. The executive committee shall exercise and act with full authority of the state board of directors to govern the GRA and act in its best interest. The 6.02, the executive committee shall consist of the elected officers of the GRA. The board of directors is actually broader, and I even think composition 7.01 may have changed a little bit, but the point is there's a big board and a little board, and the little board is essentially the elected officers. They are directors, they have fiduciary responsibilities to GRA Inc. And so when you see bios of the president, the first vice president, that's the relevance there. That's establishing the fact that those are fiduciaries. They have a fiduciary duty to GRA Inc. Another thing that I know a few slides prior I said there may have been a period where it was just 3 of 6 dual board members. I want to note too that even GRA members, so not directors, not elected officers, just with membership, not necessarily saying a GRA member has a fiduciary duty, but even through GRA Inc.'s bylaws, there's some loyalty built in to where qualifications for membership, you must agree and uphold the principles of the National Federation of Republican Assemblies and the GRA. Termination, if you publicly support anybody that's not a member of the Republican Party, for example, if you support or encourage the election of a candidate of another party, if you otherwise discredit or dispute upon the GRA or the NFRA, and I think later versions of the bylaws, again, to point out that our violations span, a period of years. So you're constantly looking back, what are the bylaws for these violations? What are the bylaws for those violations? I think, not completely certain, but I do remember reading either the 24 or 25 version, even those, the termination and discipline of individual members, I think broadened, and it's to the point where a member can't publicly support or endorse anybody that's even running against a GRA endorsed candidate. So I think that's an important thing too, where, if you have 3 of 6 on GRA PAC LLC's board that are dual directors, and then you just have 3 GRA members, although they may not be fiduciaries per se, I think there still are some loyalty to GRA requirements that's built into their bylaws. Some key points just from this, and some of the statements that GRA Inc. has put out, earlier in the summer, in July, they focused a lot on control. They're not in control. And our commission knows this. We actually had a similar issue in September on control. And this is something that's been discussed. Control is not specifically defined in our statute, but there's probably 4 or 5 places in the Georgia Code where it is defined. And this is one of those definitions, OCGA 46-4-166. Again, this is not the Campaign Finance Act per se. I think it has something to do with natural gas or something to that effect. But I think this is pretty consistent if we were to look at a Black's Law definition of control. Control includes directly or indirectly, whether acting alone or in conjunction with others, authority to direct or cause the direction of the management or policies of a person. A voting interest of 10% or more creates a rebuttable presumption of control. A voting interest of 25% or more is deemed to constitute control. So, immediate takeaway here, if you have 3 of 6 dual board members, directly acting alone in conjunction with others, you get past the 25%. If you have 5 of 7 dual board members, you get past the 25%. So I think this is an area where I'm in disagreement with GRA Inc. when they make statements that they don't control GRA PAC LLC. Some of the emails, this was, Mr. Darnell did provide this. This was an email from Brant Frost back in October 4th, 2016. This is before GRA PAC LLC organized. They organized in 2017. But when you read the email, the Cobb Republican Assembly is pleased to announce Brant Frost help present plans to launch a new PAC that has the potential to help us reshape the political landscape in Georgia. So Cobb County Republican Assembly is saying this is a tool that we can use to reshape the political landscape in Georgia over the next several years. They're also saying that we believe this is a valuable asset in our future for state and local races. And again, all this goes back to 21.5.3 and using that statutory language, association, partnership, or other group of persons. The email on the right.
I mean, you're talking about emails that are from 2016, 2017, right?
Yes, sir.
How's that help us with these, the violations that you guys have cited?
Well, I think this goes more to association and partnership and other group of persons. I think there's joint activity talking about the Cobb County Republican Assembly talking about how they have a tool, this new PAC that we're going to start. And I think it does show an association. I think it shows a partnership. And I think it does show another grouping of persons. And I will move along, but and again, too, there's going to be statements that come out later in this PowerPoint, too, which I think there's going to be contradiction with statements that are being made in 2025 and going back to 2017.
Okay.
So there is a tie, and I do respect the commissioner's time. This is an email that was sent from Alex Johnson back on February 8th, 2017, and he's talking about, I'd like to share information regarding various Republican Assembly initiatives. These initiatives include GRA PAC membership. And again, some of the statements we're going to get to, the statements that GRA Inc. was putting out in 2025 was, this was the Frost PAC, we didn't establish this, we didn't administer this, we don't know anything that's going on. So when you have the president of GRA, calling GRA PAC a Republican Assembly initiative, I think that cuts against their argument that they're separate entities, or it favors our argument that we're looking at an association, a partnership, or another group of persons. The other email this is on an Alex Johnson email chain. This was turned over by Mr. Darnell. A few other notes. Our Vice President, Brant Frost V, is heading up the efforts to create a GRA Political Action Committee to specifically financially support GRA endorsed candidates so that the principal candidates you endorse have the financial means to win elections. And although he's, saying that the GRA Vice President, Brant Frost V, is starting this, when you see other statements that are made after the fact that, the GRA, Inc. and GRA board have nothing to do with this, I think this contradicts statements you're going to see. Another email from Alex Johnson, February 2017, 2018. If you haven't told me yet, and you have any desire to support any of the following committees, please let me know. So this is a GRA communication, and he's referring to GRA PAC as a GRA committee. And I think that tends to show an association, partnership, or other group of persons. From the GRA blog, July 30th, 2017, Paul Brown was the original president of GRA PAC LLC. I just highlighted this is a GRA communication going back to 2017, and GRA is saying Paul Brown is the president of our GRA PAC. So I think the associative is important there. Again, their argument is we're two separate entities. Well, why are you calling GRA PAC our PAC?
Cannot take it away, take our money away to spend on unauthorized, unconstitutional functions of government. To have a revolution at the ballot box, folks, we must identify and recruit, if necessary, the candidates who will stand firm. And then go to the hard work of getting them elected, to get them the money that they need to get their message out. To get money to the Georgia Republican Assembly PAC so that we can identify candidates all over this state.
And that again, that's at the 2017 GRA convention, and they're endorsing the PAC at the convention. Not saying that they can't do that, not saying that that's illegal, but there's a common theme that you're going to see. GRA is endorsing these candidates. GRA is very active in raising funds for these candidates, and GRA PAC is exclusively giving to these candidates. And exclusivity, I think, is important, because I think if we were in a situation where we had truly separate, independent entities, I think we have a more problematic lift. But our statute, I think, is broader, and that's why I think it's important to show that association, that partnership, that collective action, that other group of persons.
Cobb County, Fulton County, Cherokee County, DeKalb County, and the Lemire area of the state. We have 5 chapters, and they're being led by amazing people around the state. You all have held events to educate and inform the public, including trainings, candidate forums, and educational initiatives to let people understand the inner workings of politics that often hurt the public. A PAC has been created by our Vice President, and Paul Brown has been leading it, that's going to help give money only to candidates that we endorse, that the Republican assemblies endorse, that all of you endorse on the local level or here today at the state level.
And again, I think that cuts at their argument that these are two independent entities. They're saying this is an exclusive entity that we're going to use to support our candidates. Facebook post here, this is Georgia Republican Assembly. They're directly acting, they're a direct part of raising funds for the PAC, raising funds for the independent committee. It's not like they're just a silent actor in all this. They're very active, and they're doing a lot of legwork in one of the two components of a political committee, and that's raising money. Email from Brant Frost, June 3rd, 2019. It's a GRA PAC email, and you can see the footer at the bottom. copyright of Georgia Republican Assembly. You are getting this email because you are a member of the Georgia Republican Assembly. Our mailing address is Georgia Republican Assembly, 2 Ravenna Drive. That is the former corporate GRA address. And we'll get a little more to the significance of this. There's a couple slides later, but there's a slide that talks about people can't even tell us apart. Our own donors can't even tell us apart. Our own members can't even tell us apart. And I think there's a reason for that. I think when you're sending out GRA PAC emails to all your members and saying you're getting this because you're part of Georgia Republican Assembly and this is copyright protected by the Inc. Again, I think that cuts against independence between the 2 entities and it supports the association, partnership, or other group of persons theory.
Mr. Barrell, may I ask you, the documents that you're going through, did you obtain those only after you filed a complaint and then as a result of your subpoena power, or did you have these before you filed your complaint?
I had these before I filed the amended complaint against GRA Inc., but after I filed the original complaint that just listed GRA PAC LLC.
You got these documents after you filed after you initiated this action?
Correct.
But again, just so everyone understands, I think what you just said was the original complaint was against the PAC.
Correct.
You gathered information from subpoenas that you issued in that case. Based on the documentation and information you received, you filed an amended complaint to include the Inc.
Absolutely. And it was around September 15th that Mr. Darnell complied with a previous subpoena that I sent. And it appeared he put a good faith effort into responding to documents. There were a lot of documents he turned over. And that was around September 15th. GRA Inc. was added October 1st.
Is there some rift between the two now?
There is a rift, yes. The Frost family has left the organization. Obviously, GRA Inc. doesn't want anything to do with Ponzi scheme allegations. So yes, there has been a rift as of June 2025. Another
One
email.
question on you were talking about the encouragement of fundraising. That by itself is not your argument. I mean, a lot of companies and law firms have PACs and they encourage their employees and officers to contribute. But as long as they follow the formalities, that action by itself is not problematic in your view.
I agree with you, yes. If you're just a simple connection organization and you are, bona fide and entities, correct. A connected organization, I'm not saying they're liable because of these emails, but we'll get into it in a few slides later, and part of it is with alter ego. You see emails, there's an email specifically where one of the GRA officers said, our donors can't even tell us apart. And that goes to alter ego, and I think part of the reason why they can't tell them apart is because how GRA messages and promotes GRA PAC. So 100% agreement, just because you're a connected organization, you can still insulate yourself, but I think there's ways that you can go beyond that and not insulate yourself. Some of the other, I'll move on from other highlighted things, but there's a lot of common overlap and a lot of common themes between GRA and GRA PAC. GRA is grassroots. When they advertise the PAC, it's for the grassroots, by the grassroots. GRA, a predominant theme of their organization is holding Republican candidates accountable to constitutional and conservative values. They use the term rhino regularly in a lot of their communications. And so when you see the GRA PAC being advertised as rhino insurance, I think it does show some connection and overlap between both having the common mission, shared messaging. Just another sample email where it's going out to people because they're a member of the General Assembly, coming from the corporate mailing address. This is a Facebook post from December 18, 2019. You can see that Debbie Fisher originally posted it. Cobb County Republican Assembly, GA, apparently had it on their page. Georgia Republican Assembly posted it on their page. If you don't already know this, the GRA is the movers and shakers of the Republican Party. They are able to do things not allowed by the party itself, like endorse candidates and have a PAC to support candidates. Again, I think it cuts at independence when you're, saying, look at us, we endorse candidates and we financially support our candidates. This was a check. This was from the GRA PAC LLC finances, October 14th, 2021. It appears to be signed by Nathaniel Darnell. You can see, he's tagging East Loss contribution. So it does show some control on how this money is being spent. It's not like the donation's going to an independent PAC or an independent committee, and the PAC and the committee's deciding how to spend this money. This is specifically being designated for East Loss. And I would just add too that if and when this is spent on East Loss, we're now talking about an unregistered ballot committee. It's not something that was charged, but just another detail. And again, showing that GRA members have some control on how this money is being spent. It's not just going to an independent PAC or an independent committee. Another Facebook post from 2022, help us get our GRA endorsed candidates to victory for May 24th primary, donate to the GRA PAC. Again, it shows association, it shows collective action, it shows partnership. This is the email that I was talking about. It's from Abigail Darnell. She is one of the GRA elected officers. And it says, I suspect many of our donors don't know the difference between the GRA and the GRA PAC anyways, or assume we would donate any excess funds we have to the PAC. Is it groundbreaking evidence? No. But is it interesting that your own donors can't even tell the difference between GRA and GRA PAC? And I think a lot of it is how GRA promotes GRA PAC, the messaging that they use. Nathaniel Darnell's email, I second the motion that the GRA organization donate $2,500 to the GRA PAC to help us elect our endorsed candidates. So again, that cuts at future statements that you're going to hear where the Frost family alone controlled the PAC. Seems there's some control over how GRA money is being spent through the GRA PAC. A lot of communications that went out, and these are Georgia Republican Assembly communications. The GRA PAC exists to help candidates reflecting the values of the Georgia Republican Assembly get elected to office. Again, my argument is this is a closed shop. This is not operating like two separate independent entities. This is operating like an association. The footer on that, this was Mr. Darnell signing off on the footer. Pretty common, it's like peanut butter and jelly, they go together. You can donate to the GRA PAC here, join the GRA here. Not saying that alone is triggering liability, but these are branded one on top of the other. These are branded like a package deal. One entity's endorsing the candidates, the other entity, we're going to raise money and we're going to spend it on those candidates. This communication from May 6th, the middle paragraph that's highlighted, when it comes to donating to the candidates, one excellent resource partner we have provided is the GRA PAC. And partner, their words, but that obviously fits our language of association, partnership, or other group of persons. Next page, if you'd like to stop these candidates, oppose other candidates, throw your support behind our endorsed candidates by contribute to the GRA PAC. another GRA communication, and they're, boasting about, one of our endorsed candidates was elected with the help of the GRA PAC. And this was duplicate, it was just, different form of communication. So now more than, this is another GRA communication, it's on their blog. Now more than ever, we need to support our GRA endorsed candidates. Any donations you can make to the PAC to help us get them elected in November will work to secure them as champions for you. So again, I think it's evidence of association or other group of persons. This isn't, we have a PAC, the PAC is going to decide who to give money to. This is, we have a PAC, donate to it so we can support our candidates. So I think it does go a step further than just a connected organization relationship with a PAC. Same messaging, help our candidates by donating to the PAC. This is GRA blog post, January 17th, 2023, Nathaniel Darnell. This is from GRA's webpage. We were pleased to endorse and support, Victoria's campaign last year with canvassing and financial contributions through our GRA PAC. And so, again, when you keep saying this is our PAC, it doesn't look like two independent entities. Same thing, GRA talking about all the action they're doing, campaigning on the ground for this candidate, financially supporting his race through the GRA PAC to see him elected. GRA communication where they're talking about GRA PAC's mental state. The GRA PAC was pleased to serve as a top-level peach tea sponsor. I mean, they know that because there's significant overlap between GRA and GRA PAC. That's why they can, it's not an independent political action committee where you can say who, just the verbiage there is, shows association. Here, again, all proceeds from our convention go to our GRA PAC efforts. Our PAC, GRA PAC, is co-sponsoring the convention and handling registration. The footer on that, you can see the address that this was sent to, 5200 Dallas Highway. That's Mr. Darnell's business address. Or that's the constant contact account that sent this communication out. More, February 1st, 2023, thank you for your donations. They helped get our candidates elected. The GRA, another communication from GRA, the GRA and GRA PAC are 100% volunteer run. Later statements, if this is the Frost family PAC, how do you know how it's run? How do you know how there's no paid staff? And the reason they know is because GRA comprises the GRA PAC board. GRA communications, they have a fundraising goal for the PAC. They're directly involved again in the first component of these political entities, which is raising money. And on the back end, they're involved in where the money's going through bylaws, through the board of directors with dual duties. So that the two components of a political committee, GRA is directly involved in both elements of the political committee. Another May 16, 2023 communication. This is a GRA communication. That's why we created the GRA PAC. And the address at the footer on the bottom, 5 Dunwoody Park, Suite 100. It's either the former or current business address of Alex Johnson. But again, you know, GRA is saying that's why we created the GRA PAC. So when you see statements coming up about, we have nothing to do with this, we're a complete separate entity, you know, why are you telling everybody that you created this PAC? Thank you for partnering with us in this GRA PAC campaign effort. Again, you know, using the statutory language of partner. You know, another post, just, you know, boasting about, you know, our candidates being elected and they're financially supported by our GRA PAC. And that's a Georgia Republican Assembly communication. November 2nd, 2023 blog post, all proceeds, this is a GRA blog post, all proceeds go to our GRA PAC efforts. Our PAC, GRA PAC, is co-sponsoring the convention. January 28th, 2024, this was a candidate, Bob Smith. You can learn more about his campaign and help contribute to his race by donating to him directly or to the GRA PAC. You know, GRA is assuring that if you donate to the GRA PAC, it's going to, you know, end up with Bob Smith. So it does show that that second component of the political committee, you know, they are involved in where these funds are ultimately going. This was not really related to anything. It looked like a third-party vendor used GRA's name. You know, they talk about how they have name rights. So it's not, you'll see slides coming up, you know, the language that they used. You know, this is a PAC that somebody else created. We have nothing to do with it. Well, you have the naming rights to it. So you know, don't act like somebody just hijacked your name. Also, again, using the language of our PAC. GRA is describing GRA PAC as our PAC. This was a contribution that Georgia Republican Assembly gave to GRA PAC. Banks Wise is the current treasurer. He's an elected officer of GRA Inc. You can see he's highlighting this money is going to the May 21st primary, 2 candidates. So it shows control over where this money is actually going, not that it's going to an independent PAC or an independent committee to decide how it's spent. The email from Mr. Darnell, the GRA Executive Committee voted to give $39.50 to GRA PAC to contribute to 2 of our endorsed candidates. Again, they're directing how GRA PAC money is being spent.
Mr. Bayrock, let
Yes,
me ask you this, so if one were to accept that these entities were connected entities, that's going to be what's going to be demonstrated by all the rest of the packet?
Yes.
Just, it's sort of cumulative, it's getting to be, to me, a bit cumulative, and I appreciate how extensive it is. I wonder if that, what's the next issue that would be addressed?
I'll try and appreciate that. This is I will try and start plowing through.
And I'm not trying to speed you along, I'm just trying to be sure that I turn my attention to what, there's an issue concerning whether they're connected, and then is there another issue before us today?
I think, Commissioner, there are 2 issues.
Okay,
He's touching on the connectivity issue.
right.
If you accept that, then the other issue is, was there express advocacy and money spent on independent expenditures that weren't disclosed, which is what GRA PAC stipulated to in their side of the prelim.
Okay, because I want to focus on,
And I think some of the earlier slides had the mailers and the canvassing and phone banking to that end.
okay, all right, thank you.
But I think to your question, those are the 2 legal issues
Okay,
that
thank
are
you.
at play.
I thought this had good evidentiary value. This was GRA's website, and they have a drop-down box where you can contribute to GRA PAC. When you click on that drop-down box, again, this is on GRA's website, this is the page that comes up. The slide on the right, I just tried to enhance it so it's more readable. GRA PAC is an independent committee. GRA thought it was noteworthy that they're correctly describing the entity that was unregistered. They're not describing it as a PAC, they're describing it as an independent committee, not directly controlled by the GRA. And I would dispute the definition, our statutory definition, with what definition they're providing based on the board composition and dual board members for both boards. Another thing in this, we are proud to partner with them to help elect grassroots candidates. They're using the statutory language of partner. This was on GRA's website, they have a FAQ section, frequently asked questions. Pre-Ponzi allegation is on the left. This is how they identified GRA PAC. GRA PAC is an affiliated organization with GRA that is focused on exclusively on providing financial support for campaigns for GRA supported candidates. On the right, the right is after the allegations of the Ponzi scheme surfaced. Formerly, we had certain colleagues who borrowed our name to set up a PAC. So I just don't know how you can look at the last 40 slides and see that new disclaimer and think GRA's only fault is they let Brant Frost borrow the name. I just don't know that it adds up. The GRA PAC website, this is, when you click on it, it's promoting GRA, just showing that association and lack of independence. I did trace where the money goes from the PAC account, and again, there was direct contributions to candidates, there was indirect contributions to candidates. On the left, those are all the candidates that receive direct support, that's PAC activity. Out of that entire list, I confirmed that every single one of those recipients was a GRA endorsed candidate. So when, back in 2017, when Alex Johnson makes a statement that we're creating this PAC to exclusively support our candidates, I believe him. Allison Otto for BOE, I didn't see anything specific saying that GRA endorsed her. I think the way their bylaws are written, a local chapter would have to endorse her. So I'm not completely certain on that, but certainly from the PAC side, GRA is batting .975 with GRA PAC money that's going to their candidates. Same thing on the independent expenditure side. There were a couple names that I didn't necessarily see GRA endorsed, but again, all the independent committee activity, all that money is going to GRA or a local chapter of the RA, their endorsed candidates. So there's a lot of exclusivity there. This is only going back on our filing system, going to 2022, the financial makeup of this. I'm not going to spend a lot of time on it, but you can see in total it's a $360,000 entity. You can see First National Investments, they gave 120, and then you can see some of the other donors. But this is a combination of there's Frost money, First National is Frost money, but there's also over 200,000 in grassroots contributions, and I think a lot of that is the legwork that GRA is doing to raise this money, and they're raising it for the purpose of supporting their endorsed candidates. Not to harp on this, I know the commission has seen enough of the emails, but I want to talk about some of the statements that were put out in July early on. And this is before we were even looking at GRA. But this is an email from Nathaniel Darnell. Alex Johnson is on the email. I'm writing you about the ongoing use of the name Georgia Republican Assembly in your PAC. So allegations of a Ponzi scheme surface, suddenly 7 years of telling everybody this is our PAC, now it's Brant Frost PAC. You can see it highlighted at the bottom. You need to rename it to the Frost Family PAC. And just totally understand not wanting to associate yourself with somebody alleged in a Ponzi scheme, but definitely when you have 7 years of traction saying this is our PAC, it's pretty misleading to say, well, actually, no, this is your PAC. The other email, Brant Frost, the fifth response, I'll be closing it down very soon and sending the balance of funds to the GRA. You know, if they're saying Brant Frost is controlling this PAC, the Frost family controls it, Brant Frost doesn't even think he has the authority to get rid of the money. He's saying, I'm gonna return the property to GRA. And GRA does have, in their bylaws, when an elected officer leaves, they have to relinquish all property of GRA. So just kind of telling, you know, we're not just looking at, you know, one entity that's endorsing the candidates, a completely separate entity, the Frost family PAC, that's endorsing them. It's just not the case, and even Brent Frost doesn't even think he has control over that money. Another Twitter post that was put out, and it contained a resolution. The resolutions are passed by GRA's board, and this is a resolution that was published on July 12th, 2025. GRA PAC, which was operated independently by Brant Frost Fifth. Now, I think that's, you know, pretty misleading statement when you look into the resolution. Same thing on the Georgia Republican Assembly Twitter, or now X. You know, 162,000. Those donations were made to the PAC that the Frost family alone controlled. I just think they're false and misleading statements. And why would somebody make a false or misleading statement like that? You know, it's self-serving, but you know, they probably are expecting some fallout from other agencies. This was after the October 1st complaint, a blatant act of political retaliation. You know, this has been an entity that's been unregistered for the last 7 years. So it goes to show you, prior to the allegations of the Ponzi scheme, nobody from our office was looking at them. Nobody was trying to catch them in anything. The only reason we really caught this is because allegations of the Ponzi scheme surfaced. You and Commissioner DeMint, to your comment that you made a little bit ago, could be 45 minutes ago now, what you talked about is this information you had before or after the complaint. I can tell you that everything that you've seen here and more, I've probably had eyes on 90% of this information before GRA Inc. was added to the complaint. So it wasn't a hasty decision. It was something that was deliberated, and we looked at the law, we looked at the facts, and we thought they were appropriately named. You know, some of the things here, which, you know, go back to some of the early on emails from 2016 and 2017. The complaint falsely alleges that GRA established or administered the PAC. I mean, you have emails from GRA board members saying, we're going to start this PAC. So I just think it's a false and misleading statement. Those only serving as GRA officers never exercise decision-making authority over the PAC. I think when you look at the board composition, I think that's false. There was overlap. Initially 5 of 7, then at least 3 of 6 board members. Again, the Frost family operated the PAC. They had full and independent control over its operations, and I guess I don't know how you rectify those statements with all the evidence. And for those reasons, again, looking at just the basic statutory definitions of a PAC, of an independent committee, it's not an entity classification where, you know, it's just LLC or it's just Inc. It's a broad category. It can be an association, a partnership, or other group of persons. Again, the way persons is described or defined in our statute, it's not a person is not a person. It could be an LLC, it could be a corporation. So plain reading of 2153, I think satisfies any arguments for jurisdiction. It's a reasonable grounds hearing, but I think we got pretty far down the field. Thank you.
Thank you, Mr. Babel. Mr. Bernard? Menard.
Thank you, Mr. Chairman, members of the commission. Although I do recognize I'm standing between y'all and lunch at this point, so I will try to be brief, but also address any concerns that you do have at this stage.
I was gonna say that you have 5 minutes.
Well, brevity is the soul of wit, of course. And we appreciate sort of the exhaustive and thorough examination that has been conducted by Mr. Biowall, and note that it is the product of information that was voluntarily turned over in response to the subpoena by Mr. Darnell. So as an organization dedicated to transparency and accountability in Georgia governance, we think it's important to note that the Georgia Republican Assembly and its leadership has indeed complied with that and is not seeking to hide anything from this commission. In fact, there have been, of course, exhaustive emails going back many years outside the statute of limitations, of course. But again, this is a transparent and honest look at the role of the Georgia Republican Assembly, which is part of a larger national organization, as well as the GRA PAC, which was started in 2017 by Edwin Grant Frost V, and who remains as the only officer for that organization on the Georgia Secretary of State website. So what
Let me interrupt you just 1 second.
Certainly,
I
Mr. Chairman.
apologize. I'm gonna let you certainly give all the presentation you want to give, but factually, do you agree that, reasonable grounds exist to show that the act was violated?
Not by GRA Inc.
I know
Mr.
you're gonna make a legal argument that those are two entirely distinct entities. I'm just asking if you're gonna make any argument today that all the facts that Mr. Baywall presented, that factually, that they are not gonna meet the reasonable ground standard.
I'm not in a position to speak to that for GRA PAC. I do not represent GRA PAC. I do not have.
I'm asking you as to GRA Inc.
As to GRA Inc., yes, our position is that there are not reasonable grounds to go forward at this point with further investigation, and that in fact, there has not been any violation established. And the notice of violation, which of course outlines the violations 1 through 50, these are all the failure to register as an independent committee and the filing of supplemental and disclosure reports, which indeed the GRA Inc. could not have done. The only entity that could have filed these reports and indeed has acknowledged to you that there is reasonable grounds for pursuing further proceedings on the fact that they did not file these disclosure reports properly is GRA PAC, which again is controlled by the officers of GRA PAC, and in fact, to our knowledge and belief, has not even had any board meetings, made minutes available, or complied with various legal restrictions that may have operated.
Again, are you, I guess with respect to whether, I think we saw a lot of evidence that GRA Inc. and GRA PAC, that, they operate as an alter ego. They're actually one entity in and of themselves. What I'm trying to get at is, are you gonna make a legal argument that they are two separate entities?
Yes, we would make both a factual and legal argument that, as numerous members of the commission have acknowledged, the fact that there are two organizations that have some relationship with each other, and in fact, other organizations have been mentioned throughout this and do appear in the evidence, including the Georgia Republican Party, which Grant Frost was an officer of, the Georgia Freedom Caucus, the Georgia Freedom Fund. Those are two different organizations with different leadership. I believe the Georgia Freedom Fund may have been a First Liberty connected financial entity, whereas the Georgia Freedom Caucus is separately organized and I believe participates in legislative lobbying. Again, I'm not qualified to speak to that. All I can speak to is GRA Inc., which as an organization does not engage in making financial contributions to candidates. This is not the purpose of the GRA. This is why the GRA is organized for the purpose of membership, grassroots organization. And I was going to say how much I appreciated Mr. Biowall acknowledging that it as a grassroots organization that is dedicated to those purposes rather than for dealing with explicit financial support for candidates or campaign initiatives.
And again, maybe I'm asking a very inartful question, which I tend to do on occasion. But what I'm trying to get at is, let's assume just for the moment that these two entities are actually one and the same. Is there, assuming that to be the case, is there going to be any argument made that that there are no reasonable grounds to exist that the Campaign Finance Act was violated.
And with respect to, of course, the chairman's inquiry, that it is very difficult for me to accept, to even proceed arguendo on the idea of the alter ego liability, given the facts of based on the actions of the organizer and leader of the GRA PAC, the bylaws that the GRA PAC operated by, which specifically exempt it from the GRA having authority over how it expends money. So given the numerous factual distinctions, connected organization may be one thing, but we cannot in any way acknowledge that this was an alter ego situation.
All right, I'm going to get to why I'm actually going down this road. We've got GRA PAC that they've already said, all right, we're going to stipulate to the fact that reasonable grounds exist that the Campaign Finance Act was violated. So, considering that admission on their part, this whole question then that we're here to consider today is whether, I guess legally and to some extent factually, whether the PAC acted in coordination with the Inc. or the other way around.
Yes, that is one of the questions before the commission, certainly.
Well, what are the other questions then that we're hearing right now?
I mean, I think the connection between the actions of the GRA PAC, which I understand that they have acknowledged the reasonable grounds. I do not know what defenses they may be seeking to advance with the Office of State Administrative Hearings. There may be an argument of the issue between a political action committee and an independent committee, and the requirement that the commission or that investigators seek to impose of dual registration. Again, I do not speak for the GRA PAC. However, of course, 215320 specifically says that 215315 defines an independent committee as specifically a group of persons other than a political action committee. So I don't know if that will be part of the defense that they advance or if they intend to advance any defense. But the point is that the officers of GRA Inc. had no authority or control over the actions of GRA PAC pursuant to the legally authorized bylaws and the in fact practice of GRA PAC as organized by an individual who, as has been cited, is unfortunately appears to be involved in financial problems going back some years.
Okay, go ahead. I still don't know, but just go ahead.
Well, and I do apologize, Mr. Chairman. I'm seeking to answer your question as clearly as possible because over the years, there are certainly individuals who have participated in some capacity with both organizations. But the question of jurisdiction before this commission is whether or not the violations alleged, and in this case, the alleged violations are failure to register as an independent committee and failure to filing disclosure reports, whether those can be properly assessed or accused against the Georgia Republican Assembly Incorporated. So the idea, I suppose, the theory of liability is that somehow the GRA Inc. should have caused the GRA PAC to file these disclosure reports or to register in some different way. And so the information that we wanted to make sure to be here to provide to the commission is that there was no legal authority that the GRA Inc. had over GRA PAC. It simply does not exist. And again, I commend Mr. Biowall and appreciate him for acknowledging such critical and important facts as the lack of a linked bank account. That is the crucial factor because, of course, as the commission is well aware, that is the nature of your jurisdiction because freedom of association and our basic constitutional rights would not allow the government to come in and start criticizing people for their political actions. The authority of the commission comes in from the state's legitimate interest in making sure that money and other resources that are being transferred for the purposes of influencing campaigns, campaign committees, or candidates, that is disclosed in a reasonable and transparent fashion. And so that is what the GRA PAC was obligated to do that it did not do. And so what has not been identified at any point by Mr. Biowall is the legal authority that would allow the GRA Inc. to either force that to happen, that had any influence over those disclosure reports or their filing or their failure to file. I will note that a lot of this information that has been presented was presented in disclosure reports. And so that is.
I'm not sure that's the argument. Isn't the argument that they're one and the same? Isn't that the whole point of you showing us all this factual evidence, Mr. Baywell?
Yes, I think one prong is that both entities make up the association, partnership, or other group of persons that's in our statutory definitions. I think secondarily, outside of that, I do see evidence of alter ego and that theory of liability. So I think there's direct statutory jurisdiction, and I also think there's jurisdiction based on corporate law principles.
And the direct statutory jurisdiction is 2153, right?
Yes, sir. Other group of persons. So the independent committee can be GRA Inc. and GRA PAC LLC.
Ms. Bernard, do you have a response to that with respect to the direct liability based on that definition?
Well, it seems then that the contention of the staff attorney is that there would be then some third separate entity that would exist as the combination of GRA Inc. and GRA PAC LLC, and I don't think there's any factual basis for doing that. The GRA Incorporated was formed in 2013 by a completely different set of officers located in a different location, having a different bank account, having a different set of organizing rules. And the GRA PAC was created by Mr. Frost in 2017 with him as the sole officer on the Secretary of State website and indeed exercising, in fact, sole authority over it. And so to the point as to some of the later evidence that was presented, as a matter of fact, GRA PAC was not in any way subject to the authority or control of GRA Inc. And indeed, Mr. Biowall has not been able to point to anything within the bylaws, either version, which again, the only reason that this second version, which we have no idea if it was ever, if the GRA PAC ever decided to adopt this second set that was located as a result of Mr. Darnell ensuring that any kind of communication relevant to this discussion was presented to the commission for their consideration and transparency. There is nothing in those bylaws that allows the GRA to control the activities of the PAC. Indeed, the reference to GRA endorsed candidates is merely one of the 5 different categories that that a candidate or cause must meet in order to receive money from GRA PAC. And only one of those is an endorsement from the Georgia Republican Assembly Incorporated. And so in fact, in legality and in fact, GRA PAC was able to take actions completely uncontrolled and out of the purview and authority of the Georgia Republican Assembly Incorporated. Now, whether or not that's a desirable state of affairs could be a completely separate discussion. However, it is the state of affairs that was legally the case at all times relevant to this complaint. There simply was not the legal authority or the practical factual authority that would allow for the determination that GRA Inc. was directing the activities of GRA PAC. And again, yes, ma'am.
Is GRA Inc. an independent committee?
No, the Georgia Republican Assembly is organized as a nonprofit corporation.
Why is it not an independent committee? I read this definition. But tell me, with the definition of what is an independent committee, tell me what takes GRA Inc. out of a purview of that statute.
Because the GRA does not give money to candidates or engage in specific lobbying efforts on individual causes. The entire purpose is to allow for a place where individuals participating in grassroots politics are able to interact with educational materials and keep frankly the purview of this commission separate from that, because there are so many restrictions associated with the distribution of financial contributions that it is indeed very common for there to be separate organizations that handle this kind of specific transfer of money and contributions to campaigns.
So your position is that GRA Inc. does not expend funds for the purpose of affecting the outcome of an election, nor does it advocate the election or defeat of any particular candidate?
So it does, we do provide endorsements. The GRA does provide endorsements that are membership-based, on a vote of membership.
How is that not advocating the election or defeat, well, the election of a candidate if it issues endorsement?
Because it is not providing any resources behind that endorsement. It is not it is merely a freedom of speech and association determination by an independent body of membership that can participate in discussing political questions, including individuals who participate. But of course, the jurisdiction of this commission over independent committees is organizations that are organized for that purpose of influencing the outcomes of a particular election, cause, or a cause.
I don't read this statute as talking about the purpose. It just says if it expends funds for the purpose, not that it was organized for the purpose. If it expends funds for the purpose of affecting the outcome of an election or to advocate.
It's the receiving of donations that's not, I think she's saying. They endorse, but they don't receive donations for that purpose.
And
Well, it
yes,
says receive donations from persons and expends funds to advocate for the election. So it seems like everything I'm hearing that those two factors seem to be satisfied. No?
And it appears that you're not going to get a donation unless you're endorsed by GIA.
I don't believe that's the case. In fact, the individuals who apparently received donations from GRA PAC included individuals who may have been endorsed by an individual chapter that was under the control of Mr. Frost. And so no, according to the bylaws of GRA PAC, it was not a requirement that an individual be endorsed through GRA Inc. in order to receive.
But I bet you can't find one single instance where there's not an endorsement that they've received a donation from the PAC. They're interchangeable.
Well, and that is not our position that they are interchangeable, because again, there were not board meetings being held, there were not votes being conducted by GRA PAC upon our information and belief. They were not taking actions in accordance with any authority that was binding from GRA Inc.
So is it your statement that GRA Inc. made no expenditure in any way to support the outcome of an election? Whether it was taking an ad out, whether it was, you say endorsements, were there radio ads or TV ads doing the endorsement, or?
So the Georgia Republican Assembly Incorporated specifically avoided doing those things precisely because of the desire to comply with all relevant laws and regulations regarding disclosures.
So there was no expenditures made?
No expenditures made by GRA Inc., yes.
So how did the endorsements come?
Through a vote by membership at a convention noticed, much in the same way as the Georgia Republican Party.
How did you get that information out?
Through electronic mail, through,
That
Yes.
costs?
yes.
Is that not an expenditure?
This is an expenditure for purposes of membership meetings.
I don't know that the law distinguishes that.
Well, membership organizations are allowed to participate and have, of course, freedom of association to participate in member-driven activities such as decisions about whether certain individuals follow principles and platforms that have been identified by the membership of that organization.
Yes, I agree with that. but they're not allowed to make expenditures to affect an election without becoming an independent committee.
I think, apologies to the court reporter for that. I think for an independent committee, it does have to receive donations during a calendar year from persons who are members of, supporter of the committee, and expend funds for the purpose of affecting the outcome of an election. And so we don't believe that the GRA, as a membership organization dedicated to empowering grassroots activists to participate in government more effectively, and receives donations for the purposes of training, advocacy, but not for specific candidates or causes. That would have to be organized through, a candidate's campaign committee or a specific issue-based committee or referendum. So that is the distinction in terms of the Georgia Republican Assembly incorporated as an organization.
I just don't read that statute as saying you gotta receive the money for the purpose it says. You receive I'm just reading the words. Receives donations. Okay, check. It did do that, right? And then it says, and expends funds for the purpose of affecting the outcome of an election.
Well, and I do appreciate the commissioner's question, and I think the issue is identifying something as a committee rather than a membership organization with other goals and activities that individuals participate in together that are unrelated to the receipt of the donations or the expenditure of funds on political causes. And so, again, we do appreciate the explanations that have been provided, but again, there was no shared bank account, there was no shared address, there was no, these individuals are the dual directors identified, there were not fiduciaries to GRA PAC, and again, there simply was not the authority over GRA PAC that would have allowed for a finding that, such as the one that the commission has come to in some of these other cited opinions, which of course some of those were consent orders. So in this case, we have an individual, perhaps other individuals who have, I don't know about taken responsibility for, but certainly acknowledged that there were reasonable grounds to proceed on concerns regarding the filing of disclosures, and filing as an independent committee. And so at the very least, it would be proper to separate these two matters for the consideration of the commission, because again, a lot of the evidence that was presented, you have a number of checks signed by Brant Frost, signed for the purposes of campaign expenditures and for the purposes of supporting individual candidates. Those are not present from GRA in the Georgia Republican Assembly, which is a broader organization with a much broader purpose that specifically does not accept donations for the purposes of influencing particular political goals or activities. So there's just no evidence that we were trying to influence election outcomes in the specific way that would permit jurisdiction of the commission over Georgia Republican Assembly as a nonprofit organization in Georgia. So I would just note the Georgia Republican Assembly bylaws that again have been provided. There is no mention of the PAC. There is no mention whatsoever in the Georgia Republican Assembly bylaws about any connected political action committee and any authority. And certainly we do appreciate statements from Mr. Biowall saying, he's not saying that we're liable because of these emails. Certainly, there are individuals who work together in a number of capacities, and there are going to be overlaps in groups that participate. But the question is whether or not there was any sufficient overlap that would allow for the finding of control. And even under the definition that was outlined, I believe Mr. Biowall took that from I think it was the public utilities section of the code, which, as we all know, that sometimes you've got to find useful definitions in the code from several different places. But even that definition of control was simply the possession of authority to direct activity. Because there was no actual authority for Georgia Republican Assembly Incorporated or any of its officers to direct the activities of GRA PAC. That would be the necessary finding in order for there to be reasonable grounds to proceed against the Georgia Republican Assembly Incorporated as an organization. There was no possession of authority to direct. And it's not because we haven't seen the evidence. We've seen the evidence. The evidence is in the form of bylaws, corporate registrations, and actual financial donations that have been made. And there's simply that possession of authority to direct activity does not exist. There are relationships, certainly, but there is not the possession of authority to direct the activities that would allow this commission to find that somehow the Georgia Republican Assembly should have registered the GRA PAC as an independent committee or filed these disclosure reports that are outlined in the notice of violations. I'm just, I will note that, just make sure. I will just note there was compliance with subpoenas at every stage, a commitment to transparency, the separate bank accounts, the lack of common control. Again, even the individuals that were spoken to by Mr. Biowall, they recalled it as an honorary board membership, which would of course explain why no board meetings were being held. So while we're certainly not trying to throw anyone under the bus, so to speak, the individual who is legally responsible for the activities of the GRA PAC as an organization organized under the laws of Georgia, that person is responsible for filing disclosure reports and correctly filing as either an independent committee, a political action committee, or perhaps as both. Perhaps that is the new standard. And so these violations that have been alleged against GRA PAC, there is not the common control that would be necessary to say that somehow the Georgia Republican Assembly Incorporated should have, there was no mechanism by which the Georgia Republican Assembly Incorporated could have forced the GRA PAC to comply with the statute and file disclosure reports as specified in violations 1 through 50. That lack of a legal or factual mechanism, we believe, is what bars any further proceedings against the Georgia Republican Assembly. Well, of course, I do not in any way abandon our concern regarding the verification and oath of the amended complaint. And as I reiterate that I am here on special appearance rather than acknowledging jurisdiction, but the factual issue is that there was simply no legal mechanism for that to occur. GRA PAC LLC is responsible for the actions of GRA PAC LLC. I'm happy to answer any other questions or concerns, but again, we have not been able to find any more on-point examples than Mr. Biowall has of situations in which two organizations were considered to be connected for the purposes of direction or control, in which there were separate bank accounts, separate times of formation, separate individuals having actual authority or serving as officers. And so we don't believe, and again, just to address the point one more time, the funds from GRA PAC were not used exclusively for GRA endorsed candidates. And again, I would just note for the commissioners, the individual chapter that was controlled by Mr. Frost in West Georgia is not the same entity as the Georgia Republican Assembly Incorporated. And so because the staff attorney is seeking to impose that liability on Georgia Republican Assembly Incorporated, that distinction may be legalistic, but it is a very important one in both law and fact. And So I believe that's what we're just going to stand on at this point. We're making a special appearance denying jurisdiction. We have the concern regarding the lack of a verified complaint, which I believe Mr. Bywall has acknowledged that he did not make a verified complaint. We don't believe that a rule of the commission, as august as it is, would ever be able to legally trump the Georgia statute that specifically requires a staff attorney to make a verified complaint under circumstances like this, because frankly, there's a lot of theory that has accompanied the evidence presented, but there has been nothing to provide that actual legal and factual mechanism of control that would allow the Georgia Republican Assembly Incorporated to be held responsible for the actions of GRA PAC. Thank
You made reference to this, I want to make sure I have this right. You talked about the times of formation.
Yes.
Give me those two dates again.
The Georgia Republican Assembly Incorporated was in 2013, and the GRA PAC was incorporated in 2017.
I was curious about the order between the two, because I saw some reference in here to, but it doesn't matter, okay.
Thank you.
Thank
So
you.
yes, the Georgia Republican Assembly Incorporated could not have filed the disclosure reports, could not have made the registrations that are being referenced in the violations. We could not do them as a matter of law, we could not do them as a matter of fact. And so for that reason, we don't believe that there would be reasonable grounds for continuing to attach the Georgia Republican Assembly Incorporated to the actions of GRA PAC and Edwin Grant Frost V.
Well, the dates in which they were formed certainly lines up with exactly what Mr. Baywall said, which was that it was GRA Inc. that actually created GRA PAC.
It was an individual who was a member of the Georgia Republican Assembly Incorporated. And it was, we're not making the argument that he did it in secret. We're not making the argument that he did it without other people knowing about it and even encouraging people to support that organization. However, that doesn't provide the common control and authority that would be necessary to legally hold the Georgia Republican Assembly Incorporated responsible for the acts of GRA PAC. So again, it was one individual who formed it, who made the registration with the Secretary of State, who operated it on an in-fact basis, and indeed, as Mr. Darnell turned over numerous emails and copious records, just to make sure. And frankly, thank you, Mr. Bywall, for reading through all those years of emails. That's a lot of record of what's going on in Georgia. But there simply was no point at which Grant Frost and the GRA PAC was subject to the legal authority and control of the Georgia Republican Assembly.
Any questions for Mr. Moore?
I have just a couple. Getting back to the chairman's comment, this stipulation that the PAC signed, which detailed the factual violations. You're saying they signed it, their attorney signed it, you're not their attorney, the PAC. And so legally, you don't know whether this happened or not, but you're not disputing it.
Correct. And in
Because
fact,
they're not your client, you have a different client.
And again, as has been mentioned, a rift is probably the appropriate term, and it preceded the public discovery of the Ponzi scheme. In fact, the Frosts had been removed from the Georgia Republican Assembly Incorporated prior to the big news that
Right.
dropped on everyone.
And the fact that they have stipulated that binds them, not you.
Yes,
Okay.
we believe that to be the case.
Second question, there is documentation that at GRA events, fundraising opportunities were provided to its members, which in any political event, this happens all the time. But you're saying that alone is not enough to show common control. We would have to go further and find the commingling of the piercing the corporate veil.
Yes.
But the fact that GRA gave its members the opportunity to donate to the PAC, and certainly there was some publicity of that, but you're saying they were still separate entities and the corporate structure should be respected. Is that?
Yes, that is our position, because of course at political conventions, there are numerous organizations that speak and make pleas for donations. However, the key issue is not whether there was any level of connection between the Georgia Republican Assembly Incorporated and GRA PAC. Clearly, there are, some individuals who participated in both, but in order for there to be an actual liability, we would have to have, as the GRA Inc., the ability to file these reports and disclosures. And given the separate bank accounts, separate corporate locations, separate corporate registrations, and separate officers, we simply did not have that.
That's, to me, the issue
Yes.
there. Okay.
We simply did not have it. And again, as a matter of practice and lessons learned in politics, it can certainly be discussed whether that arrangement is optimal. However, what it was is that there was no legal authority or control or ability to comply with the commission in a way that would have prevented these violations from occurring, if they did occur.
I have a question for Mr. Baywell whenever
That's
the
what I
do too, but go ahead.
'Cause, again, if there are reasonable grounds to believe that these two entities were one and the same, then the fact the PAC signed the stipulation that reasonable grounds exist on the factual basis with regard to all the various violations, that provides at least some evidence that reasonable grounds exist that GRA Inc. also violated the act.
If they were the same entity, then yes, but
That's what I asked at the very beginning. That's what
Well,
I
and
was trying to get at.
it's so hard with these hypotheticals, Mr. Chairman, because it is difficult. Obviously, there are the similarities in name and the individuals who were members of both organizations. We do not deny that, those similarities exist. But what we do strenuously deny is we had no authority whatsoever over that signature and that admission of reasonable grounds. Frankly, I showed up here this morning fully expecting either Mr. Frost or Mr. Sabatini to be present. So the very first we heard of this acknowledgement of responsibility and reasonable grounds was today, and I in fact still have not seen a copy of what was signed by GRA PAC. So again, if they were the same entity, then there would be other issues of improper and illegal behavior occurring by purporting to bind and admit to guilt before the commission, which we, to be clear, do not do.
Well, again, I think that the issue now has been narrowed, and I think that Commissioner DeMint has actually touched on this. And I think that, one way for us to proceed, or to think about proceeding, one of these different arguments that we can make based on the brief that the commission staff provided, is that, are there reasonable grounds to believe that GRA Inc. is subject to this direct liability based on the statutory definition? So, we read that law, are there reasonable grounds to believe that GRA Inc. fits within those definitions? If so, we find reasonable grounds and it's off to OSA. Right, Mr. Baywell?
I think you're correct that it should be off to OSA. I will just clarify one thing though. I did not consider the substantive allegations, meaning violations 1 through 50. I did not consider the LLC stipulating that to be binding on GRA Inc. Part of the reason why I added them is so we don't get down the road and try going after them for liability and they've never had a chance to litigate this. I did present substantive evidence for counts 1 through 50. Count 1 was the lack of registration. The failed disclosure reports stem from not being able to register, not being able to file those. And then I also presented substantive evidence, all the checks aligned for whatever the violations were, if it was 17 through 50. So there is substantive evidence. I don't think you should consider that stipulation as it relates to the Inc. I think that's just the LLC saying there's reasonable grounds. My approach here, and that's why I presented all those checks and all that information, is to, if they wanted to rebut those allegations, there's substantive evidence for you to say there's reasonable grounds that 1 through 50, those violations occurred.
You wanted to make sure they were on notice, is what
Yes,
you're
sir.
saying. Okay.
And now the
We get
only
that.
issue is, those violations occur, are they coming along for the ride based on the statutory definition of a PAC and an independent committee? or based on an alter ego theory.
Well, and with respect, I think the state would have to kind of select a path there. Either would have to select whether the entities were in fact alter egos or not. And I think this acknowledgement, which again I greatly appreciate from Mr. Biowall, is that of course the actions by officers and attorneys for GRA PAC LLC do not bind the Georgia Republican Assembly Incorporated, nor could they bind the Georgia Republican Assembly Incorporated. And so for that reason alone, we believe that the separation is sufficient to disestablish any sufficient control.
I've got to ask now then, Mr. Bidwell, what's the point of number 4 in the brief? You say liability on corporate law principles. Traditional corporate law principles dictate that GRA Inc. should be held liable for actions of its political fundraising wing, GRA PAC.
Because I think there's good alter ego evidence. When I originally did the complaint, it was based on the statutory definitions, but I think alter ego is a fair argument. And I would much rather be sitting in an OSA hearing and saying, I'm glad we presented this theory so they can rebut it, than being at an OSA hearing saying, sorry, how come nobody's never argued?
I do think I have to advise the board of this, the commission of this. I don't know that I agree respectfully with Ms. Bernard that the commission staff have to pick one or the other. In any number of legal pleadings, you can argue alternate theories that a law was violated. So I think the point of number 4 is you can find under the statutory definition that they are one and the same. You can find under corporate theory that they are one and the same. You can find under both, or you can find under neither. But I don't know that I agree with the premise that Mr. Baywall has to pick or choose one theory of argument or the other. He can provide all the options that this commission can consider. That's I think all I'll say about that.
And our position just, of course, would be that it is precisely these problematic actions of GRA PAC LLC and the fact that, again, in a document that I have not yet had the opportunity to review, they have apparently acknowledged and taken some level of responsibility for these failures to file. And so the question is not whether or not GRA, the Georgia Republican Assembly, is an alter ego. That was not, any of the notice of violations. Being an alter ego was not a violation that was alleged. The violations that are alleged and before the commission are failure to file disclosure reports and failure to register. These are simply not actions that could have physically or legally been taken by the Georgia Republican Assembly Incorporated. And so I appreciate Commissioner DeMint's commentary regarding independent committees, and certainly it is a very broad concept, and it is worth revisiting and further consideration. And so if anything would need to be refiled on that basis, certainly the commission would have the right to investigate and do this. But based on the violations that are being alleged now, there simply is not the factual or legal basis to assert that Georgia Republican Assembly Incorporated could have or did anything in relation to these 50 violations before the commission.
Thank you, Ms. Bernard.
Thank you very much, Mr. Chairman.
Mr.
Members,
Baywall, do you have any further response?
Just briefly, one thing
You're going to need to go to the mic.
Yes, sir. Just on the definition of control, it can be direct, indirect, it can be singular or joint. And we saw those ratios, rebuttable presumption of 10% or 25%. When you have 5 dual board members of 7, that's 70%. A dual board member has a fiduciary duty and a duty of loyalty to GRA. So when they're making decisions for GRA PAC, that's where the control is. 5 of those 7 votes, they have to be loyal to GRA. Otherwise, they're in breach of their fiduciary duty. The same thing from 2019 on, when Kay Godwin and Pat Tippett they were no longer GRA elected officers, but they were still on the GRA PAC board. What the witness told me was Kay Godwin and Pat Tippett were still honorary board members. So it's possible that they were still dual board members by honorary status with GRA Inc. So in that scenario from 2019 on, you either have a 3-of-6 ratio or a 5-of-6 ratio. And if we're saying control is at 25%, 3-of-6 is 50, 5-of-7 is 75%. So that's the argument on control.
Commissioner Thompson?
So, let me ask you this. If the Inc. is a corporation, okay, let's just say that they are, and they want to make independent expenditures. So they create an independent, well, they create another entity to be that independent, even if they didn't file. So it's not the corporation that gets dinged, it's the independent committee, the LLC that would get dinged. And isn't the LLC saying, yes, we stipulate, the PAC, saying, yes, we stipulate, we should have filed? So in your summary there, aren't you almost arguing that maybe the Inc. shouldn't be there because you already have an entity that is saying that they failed to file?
But 2153 doesn't have an entity approach. It doesn't say the LLC is a PAC. It doesn't say the Inc. is a PAC. It says the association, the partnership, or other group of persons is the PAC. And so my argument is we have association, we have partnership, we have other group of persons. I'm saying that under our statutory definition, I'm saying the Inc. and the LLC are the PAC. They are the independent committee under a plain reading of our statute.
I think, Commissioner Thompson, if I understand Mr. Baylor's argument, I think he would agree with you if the PAC had its own separate controlled board. If there were people that ran the PAC that were not also board members of the Inc. But when it's one and the same, I take that to be the argument, or at least in part, that they're one and the same because the same people are controlling both. Which gets into the evidence you presented, why they call it their PAC, they started.
I got that, but I thought if you set up a separate entity to do political filings, then you're at least following the spirit of the law, especially whether it's a PAC or independent committee. You did, I mean, if the Inc. would have just said, yes, that was ours, and the PAC, and we messed it up, I mean, I don't think that we should hold both of them accountable. If they said that, I'm not saying I'm there, I'm just saying, I was just asking a question.
And your argument is focusing on the corporate code, not the Campaign Finance Act.
No, because I don't know anything about the corporate code.
Well, the corporate code is protections for separate legal entities. The Campaign Finance Act is broader because it doesn't say, we're just focusing on the entity. They're saying we're going to focus on an association, a partnership, or other group of persons. And that doesn't say, that's not to say every connected organization is going to operate this way and not insulate themselves, but I think it's problematic even if we want to take the corporate approach, which is why I raised alter ego theory. If you take the corporate approach, I think that's where those percentages are important. 5-of-7 exceeds 25%. That's why I'm saying GRA Inc. is in control of GRA PAC. That's my alter ego argument. But those are separate and distinct arguments in terms of, and that's what I intended on conveying in my brief. We have direct statutory authority, we have direct statutory jurisdiction, and I think there's a fair argument that they are one and the same. They are alter egos.
I mean, when you boil it all down, it doesn't matter, right? It doesn't matter what each individual commissioner finds is the reason to, finds that reasonable grounds exist between the two. They can fit under number 2 in the brief, they can fit under number 3 in the brief, they can fit under number 4 in the brief. It doesn't matter if we don't agree on, whether it's 2, 3, or 4. I may think it's 4, Commissioner Thompson may think it's 2, Commissioner DeMint may think it's 3. But as long as we're finding reasonable grounds exist that, you know, GRA Inc. violated the act, then we're good to go, right?
Yes, sir.
Okay.
But to that point, don't we have to specify on the reasonable grounds?
Not,
Because
no.
No, this is, sorry.
Didn't we get into this once before?
This is what I was driving at earlier about the theory. If you find reasonable grounds, what you are finding is that reasonable grounds exist that statute A was violated.
Okay.
You don't have to say because of this mailer, or that mailer, or this theory, or that theory.
But we have done that. When we send things to OSA, you list them out every time and you vote on them separately, like you
Sure.
did today. I'm just asking why this one would be different if we could just say, yes, the act has been violated. I get what you're saying.
Yeah.
I was just procedurally, how we've done it in the past, was what I was asking.
But the statute doesn't spell out whether it's 2,
It doesn't
3.
have to spell out whether it's 2, 3, or
Okay.
A.
Right.
I agree with what you're saying is that procedurally, if there is a vote that reasonable grounds exist, you have to state each violation in the statute. I agree with that,
Okay, that's what I was asking.
But
Yeah.
not how you got there.
but not how you got there.
Okay, I understand.
Again, and I think that's important here. Again, we also have to remember that it's the reasonable ground standard. You know, we're not saying that you gotta come in here today and prove it beyond a preponderance or beyond a reasonable doubt or anything like that, so.
Mr. Chairman,
Mr. Babel, can I ask you 2 questions?
Yes, sir.
In response to some earlier comments, you're not alleging here that the fact that the GRA by itself, just this one act alone, issued endorsements, triggered this case.
Correct.
That's by itself,
Correct.
that's not your argument.
Correct.
Okay.
It's how they interacted with the PAC.
I get that. And then, I think I finally figured out your corporate argument. You're arguing, and this is what, there's a corporate code argument about alter ego, which I fully get. But you're also arguing above and beyond that, even if they meticulously observed every corporate code or limited liability act requirement, they had formed, I'll call it a joint venture or a partnership, which was an association that qualified under the Campaign Finance Act as a I'll call it a joint venture,
Yes, sir.
a partnership.
Yes, sir.
And I'm a corporate lawyer, so that's how I think, so.
And you're using our statutory language when you say.
So you're saying we can either go to the corporate code and go, they jump back and forth and pierce the corporate veil, but even if they meticulously observed everything, they still formed a joint venture,
Which is a fact specific.
which qualified as an independent committee together.
Yes, sir.
I think it's only that. But I do want to clarify the endorsement by itself is not your argument.
Absolutely correct.
Any other questions for Mr. Baywall? Ms. Bernard, I'll give you a short time, but
Very briefly,
let's come to the
Mr. Chairman.
microphone.
You're
Specific.
hungry. He's ready for lunch. He's seeing
Sorry.
microwave.
That's why I wanted to be as efficient as possible.
Yeah.
But specifically as to the issue of the dual directors, there is a reason that no evidence has been identified of any votes taken that influenced the actions of GRA PAC LLC. Under information and belief, no such meetings ever occurred. There was never any opportunity for these individuals to cast votes in a particular way that would be in accordance with the interests of the Georgia Republican Assembly. So all of these references to the corporate structure, this was not, as a matter of fact, the way the GRA PAC LLC was being run. There was never a meeting at which any of these board members had the opportunity to vote or direct the actions of GRA PAC. And that is, we believe, why Ms. Godwin and others may have said they believed they were honorary board members. So that is just, I wanted to make sure to respond to that, so all this discussion of 5 of 7 and 10%.
But aren't you just arguing the whole point there? That if there was no board meetings, they wouldn't need board meetings if they've already made a decision in the other entity. So didn't you just kind of argue that it does?
Then there would be evidence of those decisions being made in the other entity. Because again, Mr. Darnell turned over emails going back a very long way, And I have complete confidence that Mr. Biowall located anything that could be in any way connected between the Georgia Republican Assembly and GRA PAC. But the fact is, GRA PAC was not operated in a way that the Georgia Republican Assembly had any factual or legal control over its actions.
With no evidence you've seen.
Well,
Because how would you know if you weren't part of it?
Well, I have confidence that Mr. Biowall would have located it, and Facebook posts and emails that imply that there is any level of connection, that does not provide the control and authority that the statute would require.
Like reasonable grounds. Okay, thank you.
Thank you. All right, are y'all ready for this? I'm going to go ahead and make a motion that reasonable grounds exist to believe that respondent Georgia Republican Assembly, Inc. violated the Campaign Finance Act, more specifically OCGA Section 21-5-34 F1 by failing to register as an independent committee. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? That motion will carry. I make a motion that reasonable grounds exist to believe that respondent Georgia Republican Assembly, Inc. violated the Campaign Finance Act, more specifically OCGA Section 21-5-34 F1A through C 15 times by failing to file the following disclosure reports. December 31, 2020 supplemental report. June 30, 2021 supplemental report. December 31, 2021 supplemental report. May 10, 2022, 2 weeks prior to May 24th, 2022 primary election report. June 30, 2022 supplemental report. December 31st, 2022 supplemental report. January 17, 2023, 2 weeks prior to January 31st, 2023 special election report. February 14, 2023, 2 weeks prior to February 28, 2023 special runoff election report. June 30, 2023 supplemental report. December 31st, 2023 supplemental report. April 1st, 2024, first day of month preceding May 21, 2024 primary election report. May 7, 2024, 2 weeks prior to May 21, 2024 primary election report. June 30, 2024 supplemental report. December 31, 2024 supplemental report. June 30, 2025 supplemental report. Do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? That motion carries. Make a motion that reasonable grounds exist to believe that respondent Georgia Republican Assembly, Inc. violated the Campaign Finance Act, more specifically in violation of OCGA Section 21-5-34 F2B 34 times by failing to report and itemize the following independent expenditures. Steadfast USA, August 6, 2020, $8,631.26. Mobilize the Message LLC. I'm sorry?
No.
Mobilize the Message LLC, April 15, 2022, $11,250. Mobilize the Message LLC, April 21st, 2022, $11,250. American Campaign Services, April 26, 2022, $9,500. Southern Pines Strategies, April 26, 2022, $5,000. American Campaign Services, April 27, 2022, $5,000. American Campaign Services, April 30, 2022, $5,000. American Campaign Services, May 5th, 2022, $7,500. Print Source, May 5th, 2022, $7,326.90. Print Source, May 5th, 2022, $713.69. Print Source, April 29, 2022, $1,179.30. American Campaign Services, May 9, 2022, $12,000. American Campaign Services, May 11, 2022, $1,500. American Campaign Services, May 10, 2022, $12,000. Print Source, May 21, 2022, $13,639.10. American Campaign Services, May 16, 2022, $2,400. Mobilize the Message, LLC, May 31st, 2022, $9,000. Print Source, June 9, 2022, $5,579.75. The Stone Ridge Group, June 8, 2022, $5,000. The Stone Ridge Group, June 22nd, 2022, $5,000. Print Source, January 10, 2023, $5,159.81. Print Source, January 13, 2023, $2,708.38. Print Source, January 16, 2023, $2,708.38. Minuteman Press, February 1, 2023, $192.54. Minuteman Press, February 3rd, 2023, $96.43. Hazlitt Industries, LLC, February 7, 2023, $5,000. Print Source, February 7, 2023, $2,758.43. Minuteman Press, February 13, 2023, $666.44. Print Source, February 16, 2023, $2,758.47. Minuteman Press, February 20, 2023, $1,300.42. Hazlitt Industries, February 28, 2023, $15,000. Minuteman Press, March 9, 2023, $1,502.69. Landmark Communications, March 26, 2024, $4,146. Minuteman Press, May 7, 2024, $4,690.98. Do I have a second?
Second, with one correction.
Yes.
On the number 49, Landmark Communications, should read March 6, 2024.
What did I say?
26.
Very good. We got a motion, then an amended motion. Do we have a second to the amended motion?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you very much.
Sir?
I can't believe that's the only one that
I know, me either.
All right, I think that we're going to make this sort of a brief lunch recess. What do y'all think in terms of getting back here? Any suggestions?
3 minutes.
30 should be.
30 minutes, good enough?
Sure.
30 minutes? Commissioner Byrd, is that good? Okay. We'll be back, we're going to be in recess for right about 30 minutes. Thank you. Commissioner Byrd will be rejoining us here momentarily. It looks like we're going to move to item 4 on the agenda, which are the consent orders. I'm just going to go ahead and state for the record, just real quick, item E, which is case number 25-0065-C, in the matter of Tommy Smith. We're going to remove that one from the consent order agenda, and we will revisit that hopefully at our next meeting, or I guess we're afterwards. Again, I don't want to say for sure that we know exactly what may happen with that, but that's certainly what we anticipate.
Okay.
We're going to go ahead then and start with item 4A. It's case number 24-0052-C in the matter of Keisha Waits. It's like Mr. Baywall, you're on this first group.
I don't
Yes.
think so. No, it's all right.
Position A, Keisha Waits, case 24-0052-C. Ms. Waits was a former City of Atlanta council member and candidate for Fulton County Superior Court clerk in the 2024 election cycle. She agreed on 4 violations of the Campaign Finance Act, OCGA 21-5-30.2C. This was receiving a campaign contribution from a public agency. The value of the contribution was $24,963. Violation 2, she violated OCGA 21-5-34B 6 times by failing to report contributions or expenditures on, it was 3 different CCDRs that she filed 0 reports, and she did have activity during those periods. She had, between those 3 periods collectively, there was $65,000 she raised and spent and did not report. Violation 3, OCGA 21-5-33B1D. This was a violation that occurred because Ms. Waits had intermingled her city council campaign account with expenditures for her clerk account. So based on the intermingling of funds, that did violate 21-5-33B1D. And that statutory section essentially says that if you receive contributions for a position, you can only use those in future elections for that same position. So that's the violation. And lastly, 4, she violated Georgia Comp Rules and Regulations, Rule 189-3-.05, 13 times. This was a series of expenditures that she reported on her, I think it was June 30th, 2022 CCDR, and she failed to itemize the end recipient for those transactions. We agreed upon a civil penalty of $14,000 to resolve this matter. We'll also let the commissioners know that the City of Atlanta Ethics Department, they picked this up because City of Atlanta funds were used for violation 1, contributions from a public agency. They have a complaint process. They have an initial decision already. They're seeking restitution and fines against Mr. Waits in addition to this. And they're seeking $30,000, approximately $30,000 from her.
Okay. Item B has been removed from the calendar. Item C, we've got case number 25-0024-C in the matter of Cobb Children First. Are we doing C and D together, or are we going to do them separate?
We can do them separate, but they are connected, and there are some administrative dismissals that are connected with this too.
Well, just go ahead and proceed with item C.
Cobb Children First was a political action committee that was active during the 2024 election cycle. There were 3 affiliated committees that all gave maximum contributions to 3 of the same candidates. The result of this were 2 of the 3 entities, those contributions exceeded maximum limits. One of the entities' contributions was within the limits. And our rule and regulation 189-6-.04, that essentially says that contributions from affiliated political committees are aggregated for purposes of contribution limits. So the end result of this, Cobb Children First, they contributed $16,500 in contributions among those 5 transactions. That was the total amount, but that amount exceeded contribution limits. They agreed upon a penalty of $5,000, and I'll also add for this and for position B, the 3 candidates that received those contributions, they remitted funds, the illegal contributions. In total, $24,800 was remitted to the state.
Okay. Let's move on to item D, excuse me, 25-0025-C in the matter of business supporting schools.
Business Supporting Schools was one of the other political action committees that was active in 2024. And this is a companion complaint with position C, Cobb Children First. They had the same violation. They made 5 total contributions totaling $16,500. That did violate Georgia Comp Rules and Regulations Rule 189-6-.04 5 times, and they agreed upon a payment of $5,000 civil penalty.
Okay. Ms. Judd, we're moving to yours. Who's got L now?
I do.
Okay. Sorry, we'll come back to you since you've already moved. Item F is case number 24-0092-C in the matter of Beatrice Williams.
Yes, Ms. Williams was an unsuccessful candidate for Lawrence County Superior Court Clerk in the 2024 general election. This was a third-party complaint that the commission received back in August of 2024, alleging that Ms. Williams did not file her PFDS within 15 days of qualifying. Upon investigation, we did locate that filing from March 7th, 2024. However, from reviewing the rest of her filings, she did not terminate her campaign after she lost her election. So her violation is OCGA 21534M, and that's failing to file her final report and termination statement for the general election of 2024. She received a $125 late filing fee, $125 civil penalty for a total of $250, and she has already paid that in full.
Okay. Item G, case number 25-0066-C in the matter of Murtis Johnson.
Ms. Johnson is the incumbent in the Bibb County School Board District 1 seat. She was a participant in the 2024 general election. She ran unopposed in that election. She also ran for office originally in the 2022 election. This was a commission-generated complaint after the commission received an open records request. We noticed that there were some missed filings and she had not filed any PFDS filings. So she has 4 violations of OCGA 21550A for failing to file her 2021 calendar year PFDS, failing to file her 2022 calendar year PFDS, failing to file her 2023 calendar year PFDS, and failing to file her 2024 calendar year PFDS. She was assessed $500 in late filing fees for those documents and a $300 civil penalty to total $800. She has already paid that fine as well.
Item H, 25-0071-C in the matter of Cynthia Adams.
Ms. Judge Adams is a Superior Court judge in Douglas County. She was appointed to the bench in 2017, was subsequently the successful candidate in 2018 and 2022 in those general elections. This was a commission-initiated complaint that was generated from an audit that was completed on Douglas County. Judge Adams failed to file her 2024 calendar year PFDS for a violation of OCGA 21550. And then she also violated OCGA 21534B1C 10 times. On 2 different reports in 2022 during that election, she failed to disclose the end recipients of 10 different expenditures that were made. This was just an error on her part. She wrote her own name as, she was the payor, but she wrote herself as the payee. So she went back and amended all of her filings. She produced all of her receipts. So it was just an error. She was very apologetic. She received a $125 late filing fee, a $1,375 civil penalty, to total $1,500, and she has already paid that fine in full.
Item I, case number 25-0077-C in the matter of Fabian Velasquez.
Yes, Mr. Velasquez was an unsuccessful candidate for mayor in the city of Warner Robins in the 2025 general election that just occurred. This was a commission-generated complaint after we were notified by that city clerk that they noticed yard signs out and about and there was not a DOI filed. So we initiated a complaint, and that violation is for OCGA 21530G for those pre-DOI contributions and expenditures. He was about 95% self-funded, just buying his own yard signs and ads and those kinds of things. He also, after reviewing all of his bank statements, reviewing all of his records, he would have needed to have filed that April 30th, 2025 CCDR So he violated OCGA 21534C2A, and then he violated that twice by failing to file the June 30th election year CCDR as well. So we assessed a $250 late filing fee, as well as a $2,250 civil penalty, to total $2,500 to account for all that pre-GOI spending and those missed filings.
The local clerk called our office? Is that what happened?
Yes, they reached out to our office and provided the evidence of the yard signs and stated that they had not received a GOI, and that's how we initiated our complaint.
It's like a new tip line. Sorry. Item K, case number 24-0068-C in the matter of Kim Jenkins.
I think we skipped item J.
No, I had already put a check mark beside it. I'm really sorry. Case number 25-0083-C in the matter of Stephen Hickey.
Yes, Mr. Hickey was an unsuccessful candidate for the Sandy Springs City Council District 4 in the 2025 general election. This was a third-party complaint that we received alleging that he did not timely file his PFDS within 15 days of qualifying. He did file that 4 days late. It also alleged that he had not filed a DOI, and that person had noticed yard signs out in the community. So his violations are OCGA 21550A for failing to timely file the PFDS, which a late fee was assessed for that late filing, and an OCGA 21530G for expending about $1,000 of his own money buying his own yard signs prior to filing the DOI. So he was assessed a total of $250 fine, and he basically just acknowledged that he didn't realize he needed to file these documents when he was buying things himself.
Okay. Now we'll go to case number 24-0068-C in the matter of Kim Jenkins.
Ms. Jenkins was an unsuccessful candidate for District 8 Commissioner in Macon-Bibb County in the 2024 election cycle. This was a third-party complaint that alleged violations of OCGA 21550A, where she failed to file her 2023 calendar year PFDS within 15 days of qualifying. She also failed or violated OCGA 21534C2A by failing to file her April 30th, 2024 election year CCDR. She was assessed a $250 late filing fee and a $250 civil penalty, so $500 total. She just stated she was a first-time candidate, didn't realize she was supposed to file those things, which are now filed. And she has paid her fine as well.
Okay. Item L, it's going to be case number 24-0044-C in the matter of Renee Godwin.
Ms. Godwin is the current Douglas County coroner. She was successful in the 2016, 2020, and 2024 election cycles. She had 7 CCDR violations of OCGA 21-5-34C. She also had 2 PFDS violations of OCGA 21-5-50A. She agreed upon payment of late fees in the amount of $1,125 and payment of a civil penalty in the amount of $875, a total penalty of $2,000.
All right. Did I skip any other cases? Do we have anyone that signed up for public comment with regard to the consent orders?
We do have one, Mr. Chairman.
Okay. State your name first when you get up there for the court reporting purposes, please.
Hello, my name is Seth Levy, and I'm speaking on behalf of New Southern Majority, the organization which brought the complaint in the Cobb County School Board elections matter.
All right, so is this under the Cobb Children First and the Business Supporting Schools cases?
Yes.
All right, you're speaking as to both cases?
Yes.
Okay, we'll give you 5 minutes on public comment, okay?
Understood. Thank you very much. Elections have rules to ensure fairness so that voters can trust the process and the outcomes. I feel confident in saying that donations made through hastily formed shell companies do not pass the smell test for voters of all political stripes. We brought this complaint because we believe voters have a right to know who exactly is funding their elections. And we hope the scheme we have uncovered will prompt new policies and laws that provide for greater campaign finance transparency. All elections are important, but the elections in our complaint were for school board. They have an outsized impact on children and families. They will ultimately determine what is taught in schools, what measures are taken to protect the health and safety of children while at school, and how billions in tax dollars are spent. Evading campaign finance laws robs parents and citizens of making informed decisions about what kind of future they want for the children of Cobb County. It undermines trust in elections and makes voters feel that their vote does not count, fueling low turnout. I will not pretend that New Southern Majority does not have its own point of view regarding who should be on the Cobb School Board. We were involved in these 2024 races, but we follow the law. We did not set up shell corporations to hide our activity. Everything we did in these elections was reported under our name on campaign finance reports. You do not have to dig through corporate registration documents on the Secretary of State's website to untangle our activity. And to be clear, I'm not bragging here. This is not exactly a high standard to meet. New Southern Majority is both grateful for and encouraged by the Commission's review of the evidence and for the ultimate determination that violations occurred and that several parties are being held accountable. But it is disappointing that the people and the organization at the center of this scheme to use shell corporations to hide identities and exceed campaign contribution limits, Jonathan Crumley and Freeman Mathis and Gary, are the only ones not paying a penalty. The recipients of the donations are being forced to partially forfeit the money, and the shell companies are being fined.
I want to just point out to you, okay, that we're only talking about these two particular cases. You may now be addressing matters that may fall under different cases. So I want you to make sure that you stick to the two cases that are included on this consent order agenda, okay?
I understand, and they are kind of all like intermingled and related.
Well, I think that they're different cases because some of them appear on the consent order part of the agenda and then some appear under administrative dismissal. So again, I just want you to constrain yourself, with these comments as it relates to the two cases that are on the consent order agenda, okay?
I understand, and you need to interrupt me because you disagree. I'll understand. So, as I was saying, the recipients of the donations are being forced to partially forfeit the money, which was just stated, the school board members. And the shell companies are being fined, but somehow Mr. Crumley and Freeman Mathis have escaped accountability.
All right, that's going to be my second warning, okay?
Okay. I believe this is within side of it. I would add that if Freeman Mathis is allowed to pay those
Okay,
fines,
that's gonna
which
be
were
it.
just.
I gave you multiple warnings, okay? Your public comments now concluded.
Okay.
Do we have any further public comment, Mr. Baywall?
No, sir.
I'm going to move to, I'll make a motion to adopt the consent orders as presented. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right, that motion carries. Those consent orders are approved as presented. Item 5 on the agenda is going to be administrative dismissals. Any comment from any of the commissioners with respect to the administrative dismissals? Hearing none, we will go ahead and move to item 6 on the agenda, which is the OSA decision in case number 24-0058-C in the matter of Shakita Maxwell. Looks like Mr. Baywall, you're presenting on that one or no?
I think Ms. Young is going to.
Okay. Ms. Young, if you want to, I'll just sort of exercise privilege. I don't think anyone is going to care about it, but do you want to do this in connection with the report of the Attorney General's office as well, or no?
Certainly.
Okay.
I don't have much to report in addition to this, so I can just tack on a few sentences at the end of this if you'd like, or we can push this.
I don't know, I've gotten some looks otherwise, so I'm thinking that maybe we'll just,
No,
if you don't have anything more to add after that, just go ahead and address this Shakita Maxwell case. Tell us about it.
Sure. So we've received this it's an initial decision from OSA. The commission does have the ability to consider and substitute its own decision for the decision of the ALJ if it is unsatisfactory for any reason. However, we are generally really pleased with what the ALJ did in this case. We had a hearing out in Macon, under which Mr. Baywall was subjected to several hours of courtroom testimony. Ms. Maxwell represented herself very vigorously, and between consistent objections to each question that he was asked and her own questioning, really put him through his paces in terms of presenting testimony, and I want to compliment him on the good job that he did presenting a very cogent and thorough case on behalf of the commission during those proceedings. The ALJ basically found in the commission's favor on each of the claims that were presented. This was a case that involved some of the typical failure to file CCDRs, failure to list expenses. It had some additional implications in terms of having received an anonymous donation that she then used to pay her qualifying fees. So that was one of the more unusual types of situations. The ALJ did find that that was a violation of the act, that $3,000 will have to be repaid to the state treasury, and impose an additional penalty of $1,000 on top of that. One of the things that I thought was noteworthy about this order is, we're always interested to see how the ALJs apportion penalties in cases like this. And this is one where the judge went through a pretty detailed analysis of each of these things. ALJs are not always, well-versed in how the latter penalties, the increasing penalties for subsequent violations of the same act work, and the stacking of penalties. And this judge did acknowledge, that there's the ability to do that. Kind of declined in some of these for the repeated file the CCDRs, decided to penalize just $1,000 each rather than ramping them up for the subsequent violations. He acknowledged that he could have done that, but because this is a campaign that kind of failed to launch and did not have a whole lot of additional income after an initial round of contributions, which were not very substantial, I think he felt that would be kind of overkill to penalize this person to that degree, but did acknowledge that was an available penalty to do so. We did have a situation which we see with some of these decisions from time to time when judges are not real familiar with ethics cases where we had to have him reissue the decision because he initially tried to issue it as a final, non-reviewable decision. So we filed a motion for him to reissue the decision, which was granted, and so he reissued it at the beginning of November. So this board is within the time period that it could make changes to the decision if it wishes to do so. But we're generally very pleased with the results in this matter.
And I think this was the decision that was distributed to all of us already, right? Okay. I just wanted to make sure that's the one.
I think we got a copy when it was a final decision, and then
Right.
it's been corrected.
It was updated just to reflect that it's mainly instructing the respondent for, what their appellate rights and remedies are is mainly at the last page of the order that tells the respondent what to do next, and it, was amended to include that direction that they could come here. I suppose technically she's got until tomorrow to do that. If she were to try to seek to appeal that decision to this board, she could do that. But we have not yet heard anything from her in that regard.
Okay. Beyond that, would there be any other report from your office?
Just we've got a number of cases in our pipeline that, we'll be hearing about in the future. We are also working with the commission on enforcement of some out-of-state subpoenas, which are always interesting and require proceedings both in Georgia and in Florida. So we've been working on those, and that's all we've got for now.
Okay. Well, thank you very much. I'm going to go ahead and mark off, any further report under item 10 on the agenda as well.
Thank you.
Before we go to the next item on the agenda, Mr. Levy, I don't know if you've signed up or not, but with respect to public comment on item number 12, I'll give you a little more leeway on that one, okay? If you want to speak under the general public comment. We're not there yet. I just want to let you know if you want to sign up with Ms. Oh, you already did?
It was my understanding I would be speaking as a general comment, so I apologize for any confusion.
Oh, okay. That's fine. With respect to any public comment on the consent agenda, I feel like you'd have to be limited to those particular cases. I just wanted to let you know before you left or something like that, that I will, give you a little more latitude when it comes to public comment under item 12 on the agenda, okay?
Thank you, sir.
All right. Item 7 on the agenda, this is the advisory opinion for consideration. It's AO 2025-02. Did we receive any written comments on that?
No.
Has anyone signed up for any public comment on that? No?
No.
All right. Go ahead and tell us about this AO.
Yes. So this was a request that was made by, let me get the right picture. This is a request that was made from Attorney Brian Tyson of Clark Hill PLC. And he had four questions were presented for an advisory opinion from the commission. And they're all very related. It was submitted to the Ethics Commission on July 17, 2025. The four questions: can a candidate loan personal funds to a leadership committee or PAC? Second is, if a candidate is permitted to loan personal funds to a leadership committee or PAC, and then raises funds with no contribution limits into that entity for purposes of repaying the loan, can the candidate repay him or herself the unlimited funds raised, and then loan those funds to his or her candidate campaign committee? Then question 3 was, does the answer to question 2 change if the loan to the candidate committee occurs during the primary using funds raised in a leadership committee? And finally, if a candidate utilizes a leadership committee or PAC to repay a loan, which is then loaned to his or her candidate campaign committee, do contributors to that leadership committee or PAC face potential liability for participating in that effort? Essentially, with regards to these questions, Commission has a position that these are funds that the candidate can in fact loan to a leadership committee or PAC, because a candidate can make contributions, and a contribution is a loan is also a contribution. So that essentially that was the pretty simple, straightforward answer related to question 1. With regard to question 2. If a candidate is loaning personal funds to a leadership committee, and then the loan is repaid back to the candidate's really receiving their own funds back, because this was a personal loan made. So it's not as though the candidate is, getting the extra money returned to them. This is money that they already have. So the answer to that was that
It's their money, they're not being.
exactly, it's their money. At all times, this is the candidate's money. So it's the candidate's money that they're loaning, the PAC raises money, they're repaying back the candidate's money. So there's no excess contributions there. The question for number 3, no, it doesn't change if it's a primary using funds. It's the same analysis as the candidate's loans, candidate's money. Finally, if a candidate utilizes, a leadership committee or PAC to repay the loan, as a question 4, the money in this scenario is and always has been the candidate's personal funds. So there's no liability for a candidate to loan the money, and this hypothetical really didn't provide sufficient information or facts to answer the question put forth regarding contributors. That's what happens.
Any questions for Mr. Knittel?
One quick one then. The repayment of the loan, that's that's not limited to candidates, would it be if anyone loans money to a leadership committee and they get it paid back?
Sure, I think that, yes, it would, anyone, if you loan money, you get your money paid
Right,
back.
I was just saying, we're not, your opinion answers the question
Yeah, yes.
asked about the candidate, but repaying the loan would be really any creditor of the,
Applicable to.
okay.
Mhm.
I mean, that wasn't asked, so,
Yes.
but I'm asking.
Same as, same as in it's in code that a candidate with a campaign committee is on, can take a loan from a credit institution. That answers your question.
Right.
The bank gets paid their money back, probably with interest,
Mhm.
presumably with interest. So it's not limited to just a candidate.
Gotcha.
There are other provisions.
But again, these AOs are limited to what they are.
Yeah.
Yes.
They're not addressing any,
Answering the specific questions that were asked.
Right. So I'll tell you, there are a couple things that I want to point out. Again, we're certainly getting on the right track in terms of limiting, these things to the questions that are asked. Y'all know where I've stood on these, for years, that these things have been so long and they've included completely irrelevant, information. So again, I want to give you that pat on the back that I feel like, we're going where we need to go on this. Conclusion number 4, I'm right there with you. I don't think that we could, answer that question. I do think there are a couple of things, and I think that these are going to be, I guess, scrivener's errors to some degree, so I don't know if anyone is actually going to be terribly concerned about these, but if you look at number 3, I just don't really want there to be confusion down the road about, well, what exactly did this mean? It says no, and then the loan to the candidate committee can be made with whatever personal funds the candidate chooses to do so, whether during a primary or general election. I think, does anyone else have any concern with what that means? Because it doesn't really make complete and total sense to me.
It's like if I wrote it. Is what you say.
I mean, y'all tell me, maybe I'm misreading this thing, I just,
You're on number 3.
yes.
I think it recognizes that an individual in the aggregate has personal funds, but they may be in different accounts, different types of accounts, different we're not, I think we're trying to say, if it's your money, wherever you pull your money from is fine. But
It's more in the phrase on the second line, chooses to do so.
It's like it's missing a word or a punctuation or
Where it's
something.
got too many
Yeah.
words in there or
so,
something.
Yeah.
Whatever personal funds.
chooses to do so could just be replaced with possesses, whether during a primary or general. I mean, is that-
I don't know, yeah.
Chooses to use, isn't that what it really is?
Chooses to use it.
Yeah,
That's
probably
exactly what
better.
I think it is.
Use is what I think it
So it
So
should
instead
be
of-
chooses to use.
So do so becomes uses,
Right. And again,
to use, not uses.
I think that's, I hope everyone agrees with me that that's
That-
more in a
very
scrivener's
reasonable.
thing, that, so
Yeah.
we don't need to publish this again or to do anything with that. So, I'll just change that here, just to use. Y'all gotta give me just one more second on this. Commissioner Wise, bear with me, please.
No problem.
I'm okay, I guess, since the hypothetical was in the question. Again, I'm not totally a fan of addressing these hypothetical situations, but because it was, put in the request, I'll go with it on this one. The only other thing that I see is in,
Page 2.
yeah, it's page 2 of 4. Mr. Amati has already cheated, he's looked at my notes. Where it says the requester also relies upon, 21,533. I think this is where we talk about the requester for the first time, so I just think it should be limited to something along the lines of, the requester relies upon, or the requester requester references this code section or something like that. Again, am I being way too technical for everyone else?
Would striking the word also,
I think it would.
yeah, if you strike the word also before relies upon, I think that drives it.
And this will be my last comment, I promise you guys. Is the requester really relying on anything, upon anything, or are they just asking us about it?
Well, in the requester's submission to us,
Did they try to answer the question
Yes.
first?
and
So,
so
yeah.
like I say, perhaps could have incorporated that more fully.
But we want it short,
I was
so.
trying to make it.
All right, I'll just go with that. Just, my suggestion is mark out the word also. I promise I'll stop now. These things just,
You're a big fan, right?
I don't know if we would do these if the law didn't say that we had to do them. I'm trying to look out there.
Yeah.
You should get a copy of his with all his little red marks all over it. Put it in your office.
If only internally, perhaps, a proofreader sort of system as well.
Right. Do we have any other questions, comments with regard to this?
You could say sites, if that's what you're talking about.
That's exactly,
That's a better.
that's what I think that would be a great change.
We're gonna have Commissioner Dement write the next thing.
I love words.
Yes, so it should say the requester cites OCGA his analysis of.
Thank you, Commissioner.
If she and I sat down together, you guys might have no fighting chance. All right, any other questions, comments with respect to the AO? All right, do I hear a motion?
Move to approve as amended?
Got a motion, a second?
Second.
Got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right. 2025-02 is adopted. We'll move to item 8 on the agenda. It's a new rule for consideration. Who's doing this one? Mr. Baywalk?
And this is a new rule we proposed partly in response to a consent agreement we had back in September. And the rule is the definition of a controlling interest. This pertains to 21-533B2E. And that's a prohibition on how a candidate can expend excess contributions. The rule, the specific rule at issue is a candidate may not expend excess campaign contributions to a nonprofit agency that they have a controlling interest in. And the last round of cases, I don't think we could have been as aggressive because the argument was controlling interest wasn't defined. We think it should be 51%. And this particular candidate remitted excess contributions to a nonprofit that he was one of 3 board members. So his argument was, one of 3, I have 33% voting right. I'm under the belief that as long as I'm not at 50%, this is a legal contribution. Again, outside of the statute, we felt like we had a good argument. And this, changing this is just to beef up our argument more going forward. The statutory language says, nothing in this code section shall authorize a candidate to expend these funds to the nonprofit they have a controlling interest in. And we thought the legislative intent, that's strong. That's why we use that 10% language. We don't think the legislative intent is, just start a nonprofit where there's 5 board members and you're only 20%. We think the message is find another PAC, find another nonprofit. Don't take the risk if you have an interest in this nonprofit. This is something that I talked with Mr. Burge on, and after the last commission meeting, Mr. Knittel asked me to get in touch with Mr. Burge because he had some commentary on this, and this is the rule that we're proposing.
To clarify, does beef up the statutory language about not giving campaign money to a nonprofit you have a controlling interest of. But I think it's also good to provide clarity, because after that case in September, we had a lot of feedback of, well, we would like a bright line rule to tell us what that means. And so, you know, is it a little bit of a sword? Yes, it's also a little bit of a shield for people. So I think it's a fair rule, whatever that number is that we agree upon. I think it's a fair thing for us to do for everyone to know what the rule and playing field is.
I actually agree with that wholeheartedly. The note that I had written down was, is this really about beefing up our argument, or is it more about providing notice of what the commission's position is going to be on that, you know, moving forward? I
cheated on your notes again.
You may have, very well. Did we receive any written comments on this one? Do we have anyone signed up for any public comments with respect to the proposed rule?
I have one request or suggestion. Would it be consistent with the intentions of the group if we added where it says directly or indirectly the power to direct? In my view, we might want to say the power or authority.
Yeah.
Because power and authority really are not the same thing in the law. You know, power is sort of factual, like I can do this. And authority is the documents or the bylaws, you know, give me the authority to do
Yeah,
it.
I like that.
Commissioner Birch?
I'm fine,
That's okay.
as long as you still name the rule after me.
What do y'all think, I mean, in terms of a substantive change of that? Are we gonna have to do any kind of renotice or anything?
Well, I'm not trying to throw a wrench in things. I mean,
No.
they're close, but power and, I Googled it just to be sure that I wasn't thinking the wrong path, but power and authority are not the same thing.
What is
Yeah,
that?
yeah,
I mean, if you're adding an extra step that's, you know, defined differently in the law, like you said, I don't think I think it has to be reposted.
Yeah.
Because you're changing the intent of it.
I was getting ready to ask, you know,
Yeah.
what's our power and authority of adopting the rules? Well, our rulemaking, you know, power.
Yeah.
I'm now saying, you know, our power and authority.
Okay.
I think it's different.
Yeah, no, I think we're in a,
I think you have to repost it.
yeah, I don't know that that's wrong.
Of course not.
If I may just add one thing, and I tied this to another statutory section, and used a lot of that language from that statutory section because I did not want to legislate. So that's just one factor. I don't have any position.
Can I make a suggestion, Mr. Chair? I would suggest we, if it's the will of this body, adopt this rule. We'll go back and look at the statute and see if adding authority sort of exceeds what is in statute. And if we can do that, we'll bring it back to add that little phrase into it. And if not, maybe we would be legislating beyond our bounds and we shouldn't do that anyways.
I don't have a problem with that.
Suits me.
Okay. Do I have a motion?
Move to approve in the
Got it.
original form.
I got a motion, any second? I'll second it. Any discussion? Hearing none, I'll call the question, all in favor say aye.
Aye.
Any opposed? All right, that passes. I'm making a star on this. Ms. Easterwood, if you will also make sure that I remember to come back to this, you know, next time. I appreciate it.
Make a star. You can make a mood. He'll make a star, you make a mood.
A little sticker.
All right, we're gonna move to, item 9 on the agenda, report of the executive director.
I'll be brief, just two brief items. As I was telling Commissioner Dement, because she's next, is her second meeting, the rest of you all know this, there's an annual conference, an international ethics conference, that every state ethics commission, every large city ethics commission, as well as ethics commissions in Canada, Mexico, I think Commissioner Thompson said France too, I didn't realize that. But there's an international ethics conference that happens every year. It's usually in really fun places we get to go. This year it is here in Atlanta. We are hosting, which I'm just thrilled about. We do have significant involvement in this. I'll actually be on a few of the panels. We have the governor delivering the keynote welcome introduction on, I think, Monday morning. There's some other sort of roundtables, and then a lot of networking we'll be doing as the host city. I think Mr. Cusack's actually also on a panel, a fun little fact. But that'll begin, really, it'll begin Saturday afternoon, and it'll flow through Wednesday morning. So we are, in all seriousness, excited to host and get to talk about some of the things we've been doing and interact with other agencies that deal with similar issues throughout the country. So that is coming up. The other item, legislative update, we have, Mr. Kendall and I recently testified in front of the Senate Special Investigations Committee, particularly regarding the New Georgia Project case, and what they're really, I think the thrust of that is that they're wanting to drive down into curbing illegal money influencing elections in Georgia, which is what we saw in New Georgia. There's obviously a case we spent more than a few minutes on today, has come up often in the past. Still formative stages, but they're proposing ideas that could strengthen that. One that I think Commissioner Thompson will be happy with, it was suggested by the chairman of that committee, possibly imposing some sort of criminal liability for a campaign that illegally coordinates with a super PAC to circumvent and influence elections. I don't know where that's going. It's very early in the process, but we'll be working with the legislatures, we always do, on ideas they have and how that might be best implemented. But there's always something under Title 21 in session, it seems, so I will obviously keep the commission apprised of whatever proposals end up coming out of this session. That's all I have, Mr. Chairman.
Move to item number 11 on the agenda, confirmation of the dates for the 2026 quarterly meetings. Are you leading on that? Who's leading on that?
Do you have the, all right, I just didn't have the list. Okay, so we have, we're gonna schedule 4 regular commission meetings for 2026. The first one will be in Atlanta in March, just because it's in the middle of session, and I physically, it would not be a wise idea for me to leave the General Assembly to their wiles with us out of town that late in session. So I have a few proposals. The first preferred date, and we sort of navigate a few things with this, sine die being a big one, would be March 30th, which is a Monday. If that's something that works for everyone, that would be our first proposal. The backup would be March 26th, which would be the preceding Thursday. Any issues with March 30th from any of the commissioners? I know y'all are all looking at your calendars.
You know the chairman hates Mondays.
I know he does. It's the one day I can guarantee sine die will not be right before. So I will not be going on no hours of sleep for 2 days.
Everybody good with the 30th?
All right, the next one will be in June. We will be visiting Savannah. I have 4 dates. I don't really have strong opinions on this one. They would be June 17th, which is a Wednesday, June 18th, which is a Thursday, or the next Wednesday and Thursday, the 24th and 25th. Any of those, if there's a preference.
Can you say those one more time, Dave?
June 17th, Wednesday, or the 18th, Thursday, or the 24th and 25th, which are just the next Wednesday and Thursday. And if there are no suggestions, no issues, I'll just throw out June 24th,
What day of the week is that?
Wednesday. We like to plan trainings either before or after, the day before or after when we're in areas, so that gives us flexibility. Good with you, Rick?
Yeah, I'm fine with that.
So we'll do Wednesday, June 24th. Next one will be September. Location to be determined. We're still buttoning some things down. It'll either be in Helen or Macon. We try and get a good geographical mix for these meetings.
September?
September, yeah. So the 4 options I have: September 16th, September 17th, which are Wednesday and Thursday, or the next Wednesday and Thursday, the 23rd or 24th.
I cannot do the 23rd,
Okay.
24th, or 25th.
Okay. Anyone else?
What days of the week are the 16th and 17th?
Wednesday and Thursday. You have a preference?
Where's it gonna be?
Macon
Either-
or Helen.
Yeah,
Okay.
Macon.
Gee,
That's a pretty big difference.
I'd prefer to do Helen, as it's a new area we haven't done one of these at.
Have we ever done that meeting in early October?
I think we've had a special meeting in early October.
All right. What everyone else, whatever y'all want, 16th, 17th.
We'll do the 16th then.
16th?
Yeah.
Okay.
And last one, December, we'll tentatively plan for that in Atlanta. This, again, gets, we sort of balance these COGL conferences around it. I'll throw out 3 dates in December. They're a little later in December, so I know I may get pushback, and that's fine if so. But December 14th, 15th, or 16th, which are a Monday, Tuesday, and Wednesday. If one of those 3 dates works, that'd be ideal.
I won't be here.
Is there any other?
I won't be on the board.
Presumptively, but if somebody's unappointed, you hold over. So we'll just plan as if you would.
Okay.
Do those work?
Yeah.
If you, okay.
I mean, I'm fine with the 14th. That's the
Okay.
Monday, right?
Yeah.
I know that, yeah, let's just go with that one, as long as that's okay with everyone.
Yep. Then those will be the dates, March 30th, June 24th, September 16th, and December 14th.
And where's the December 14th?
Right now, we'll say Atlanta.
Got it.
Any other commission type of business?
No more business.
All right. We'll move on to item 12 on the agenda, which is general public comment. Who do we have? Is it Mr. Levy?
I'm sorry, how do we sign up for public comment? Have we done that beforehand, or is it,
It's okay, we'll let you.
what do you sign? Is that what it means? Thank you so much, I appreciate that.
Could you spell his name?
Sure. Just give us just 1 second.
Sign.
Just give us 1 second. Good. Would you state your name and spell it?
Yes, my name is Seth Levy, Sethlevy, and I'm speaking on behalf of the New Southern Majority.
Mr. Levy, before you start, I don't want you to think that I was getting short-tempered or anything of that nature. I just, when you sign up for, the consent orders, I just want to keep it, geared toward those consent orders. But now, we're to the general portion of public comment. So we try to keep it at 5 minutes, okay? And you can begin.
I understand. Thank you, Mr. Chairman, and thank you for the opportunity to allow me to finish my comments. I'll start where I left off to be respectful of your time. And I do want to note that everything I'm about to address is contained in our complaints and communications with the Commission. New Southern Majority is both grateful and encouraged by the Commission's review of the evidence and for the ultimate determination that violations occurred and that several parties are being held accountable. But it is disappointing that the people and organization at the center of the scheme, which we allege to use shell corporations to hide identities and exceed campaign contribution limits, Jonathan Crumley and Freeman Mathis and Gary, are the only ones not paying a penalty today because our complaints against them were administratively dismissed. The recipients of the donations are being forced to partially forfeit the money. And Cobb Children First and business supporting schools are being fined. But somehow Mr. Crumley and Freeman Mathis have escaped accountability. If this is due to a deficiency with campaign finance law, then the law needs to be changed. Again, I feel confident in saying that voters across the political spectrum would agree that this doesn't pass the smell test. I would also add that if Freeman Mathis is somehow allowed to pay the fines for business supporting schools and Cobb Children First and donate money to the three candidates to replace the forfeited money, then that too is something which changes the campaign finance laws, also must fix. There are two final points that I'd like to make. The commission is only requiring that the money in excess of the $3,300 contribution limit be forfeited by the school board members. It is our belief that all of the money should be forfeited because it stems from a scheme to exceed contribution limits. I also want to note for the commission and the public that Freeman Mathis and Jonathan Crumley were less than forthcoming in their response to our complaint. In a May letter to the commission, they attempt to separate themselves from business supporting schools and Cobb Children First by pointing out that Mr. Crumley, Freeman Mathis employee, was merely the registered agent, and that Justin Miller was the driving force behind the two entities, that he was the incorporated. No information was provided on who exactly Mr. Miller is. Based on publicly available records, it appears that Mr. Miller is related to an employee who works for Mr. Crumley at his consulting company. I want to conclude by one last time calling for new campaign finance policies and laws that provide greater transparency so that the public feels confident that our elections are free and fair. It seems unlikely that this was an isolated incident, and we do not want the legacy of this complaint to be that wrongdoers simply become more careful at covering the tracks. Thank you again for your diligent attention to this matter.
Thank you, Mr. Levy. Do we have anyone else for public comment?
Yes, please.
Oh, yes, sorry.
No worries, Mr. Chairman, thank you so much, I appreciate yourself and the rest of the commission. Again, my name is Nicole Messiah, and I am presently a commissioner in DeKalb County, Georgia. So as I came before you earlier, it was just based on a case that was filed by a former candidate. That he filed it with the intention to influence the outcome of the election, both the general election, but also the runoff. That was evident by the information that had been provided both through emails and texts through to a number of constituents. Even as I stand here right now, I am really uncertain as to which of the specific allegations that this commission has found there was enough information to move forward on. By way of example, as it relates to the 6-day runoff, that would have been due on 11/27/2024. That had been filed on 11/1/2024. As it relates to the 15-day CCDR, that would have been due 10/21/2024. That had been filed on 10/10/2024. If anything, there would have been a question as it relates to the PFDR that had been filed, and that alone apparently had been filed late. As it relates to the 31-day, it was filed on 11/1/2024. And so the basis of it is, this commission is here, and I understand in so many different ways, both holding a real estate license as a broker, a law license as an attorney, and even admitted to the U.S. Supreme Court, Georgia Supreme Court, how important, and of course now being a commissioner, I take very seriously how important it is to protect the public from those of us that have arguably more authority and power in so many different ways, and where there's a public confidence, and we have the responsibility to be as transparent as clear and matter of fact as possible to protect them. In this particular instance, again, it was provoked by political rhetoric and nonsense that continues today. Each time we are before you, we have my former opposition that comes with a phone camera, just to literally take and send it out with the intent, again, to harass and to influence the election, one of which is coming up again next year. I've been transparent, even in filing more than I have to file. I filed earlier than I had to file, and I've even provided bank statements, even though I wasn't required to. So in terms of transparency and being abundantly clear, I have done that. And so I just want to make sure that as we move forward, I understand exactly what has been alleged by the commission, where it has been sufficient information, and just making sure that we're not losing the spirit of what we are here to do, which is to protect the public, and making sure that I'm adhering to the principles and responsibilities that I have, both before I became an elected and just generally as a candidate. Again, I tried to be as transparent as possible, and being late, I would argue, in this, there is still one incident, and, you know, the commission, I respect the ruling they have made. I will not, you know, challenge that, and we'll deal with that at a later time, but the point being that being late does not mean that you're being unethical. And with that, I appreciate your time, Mr. Chairman, and the rest of the commission. Thank you so much.
Thank you, ma'am. Any other public comment? We move to the last item on the agenda. Do I have a motion?
Move to adjourn.
Second?
Motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any